Thank you. Please be seated. Right. That's okay. You made me my dad. He was Robert Redford. Thank you, Mr. Cranmer. All right. Good morning, everyone. All right. This is a matter of Robert Davis versus Jocelyn Benson in her official capacity as the duly elected Secretary of State of the state of Michigan. Start Court of Claims, case number 23-000128MB. It is my privilege to be the judge assigned to this case, as well as two other matters we'll be addressing today. Thank Ms. Teresa Roberts, our court reporter, who will be with us today. So counsel, as I asked Ms. Roberts before we started, no talking over one another. And if that happens, then we'll slow down and we'll make sure that we're not doing that. So Ms. Roberts, thank you for being with the court today. On behalf of the plaintiff is Mr. Robert Davis, who is appearing in pro per. On behalf of the attorneys or for the defendant, Jocelyn Benson. Is counsel, can you make your appearance, please? All right, thank you. And on behalf of amicus curiae filer Donald J. Trump, counsel, could you make your appearances? Good morning, Your Honor. Thank you. All right, thank you. Mr. Davis, in a previous pleading in this case, attorney Andrew Patterson filed an appearance of record. Is that your understanding? No, what case was that for? I think that's incorrect. I think that he filed. However, it's your representation that you're proceeding in pro per without the assistance of Mr. Patterson in this matter or any of the election matters. Is that correct? That is correct. Okay. Oh, all right. And I don't, maybe they just got cross-filed. Obviously, we're now in excess of case 151. So we have lots of cases in the Court of Claims that we have the privilege of being part of. Okay, fine. Thank you. All right. The court has had the opportunity to review all the pleadings that have been submitted. I've read, I will not say I have read every case that has been cited, but I have read, I think, most of the salient cases. I had the benefit of research attorney assisting substantially. I did issue a previous scheduling order that provides Mr. Davis 30 minutes, Secretary of State 30 minutes, and the amicus curiae 30 minutes, with the batting order being, although now that we're done with baseball, maybe we should go to some football analogy, but that the Secretary of State would proceed first on their motion, followed by Mr. Davis, and followed by amicus. And that if the Secretary of State wished to have rebuttal, they would advise the court at some point when we get started. That was my understanding. I am not aware of, the only other matter I would point out is yesterday, either late afternoon or evening, the Supreme Court of Minnesota issued a 4-page order. I had asked my staff to make photocopies of the order and to provide it to pro se litigant Mr. Davis, to counsel for the Secretary, and to amicus. Have all three of you had an opportunity, had been provided that? Yes, sir. Okay, affirmative response by all counsel. Mr. Davis, before we proceed to, and I know you're not going to argue first, but since you're the plaintiff, my old habits as a 12-year trial judge are hard to break. I always start with the party with the burden of proof. Anyway, is there anything you would like us to address before we go into the oral discussions? You may.
Good morning, Your Honor.
Good morning.
May it please this honorable court, Robert Davis, pro se plaintiff. Just very briefly, without going into argument, since I'm going to go after esteemed Secretary of State Counsel, Ms. Mingus. Just a couple of housekeeping matters, Your Honor. As you may recall, Mr. Trump filed a motion to intervene in this case, in which this court promptly denied without prejudice. Accompanied with that motion was a motion for summary disposition, in which this court, in its order denying Mr. Trump's motion to intervene, the court did not directly address, and as a result of the court inviting them to possibly file additional pleadings or a parallel case, which they eventually did.
Right.
So I would just like for the court to either address the issue of their pending motion in my case for summary disposition, since they are not a party in my case, that the motion be either stricken or just outright denied by the court, since they're not a proper party to the action.
All right, thank you. Anything else you'd like to address before we get to the substantive oral arguments for today?
No, Your Honor.
Okay, great, thank you. All right. Counsel for the Secretary, and how do you pronounce your last name again? Mindgast. Ms. Mindgast, any position on Mr. Davis's statements or requests? Thank you. All right, for amicus filer, Mr. Kalman and I believe Mouser? Okay, Mr. Kalman. All right, would one of you like to respond, if anything, to Mr. Davis's request? So what do you believe is the status of what should the court be doing to the motion for summary disposition?
Disclosure, when we filed our motion is that we dismiss the proposed.
Okay.
Your prior order has already been.
All right. So I'm assuming from what you said, counsel, that you would have no objection to the court articulating specifically on the record that Mr. Davis's request is granted, that it is and should be considered stricken.
No objection.
Very well. Is that satisfactory, Mr. Davis?
Yes, sir.
All right. Thank you both, Mr. Davis as pro se, and thank you, counsel, for amicus. The motion that Mr. Davis sought to be stricken from the record in 00128. I think all of us understand the motion. It doesn't mean it actually disappears, and it doesn't mean that it's not potentially part of an appellate record, but the court will not consider the pleadings. Satisfactory, Mr. Davis? Satisfactory. Counsel?
No.
No objection, or no, it's not satisfactory? All right, thank you. For the Secretary, anything you need to address before we begin oral argument? Amicus. All right, thank you. My guest, you may proceed. And I'm just going to indicate right now, I'm going to set my timer. Would you like to reserve any time for rebuttal in this matter?
Sure. 2 minutes,
Oh,
just in case.
fine. Okay. All right, and I would, I didn't say this earlier, at least if I didn't say it with enough emphasis. I'm very grateful to Mr. Davis, to Ms. Meinstad, and to amicus filers. The briefing in this case, as well as in 23-137 and 23-151, were excellent. You're well and capably, and Mr. Brewer on behalf of in 137 and his colleagues, very passionately advocated your positions. It was very fine lawyering. It was a privilege to read them. They were helpful, and likewise, the amicus filers were very insightful and very helpful to the court. So all individuals, from individual citizens in West Virginia to think tanks in Washington, D.C., to everywhere else in between. I haven't read so many law review articles, maybe since I was in law school, but at any rate, thank you. Before we get started, I wanted to just acknowledge that it was a very fine reflection of the caliber of attorneys, but also of the excellent bar here and that are participating from across the country. So counsel, you may proceed.
Thank you, Your Honor. Assistant Attorney General Heather Mangas on behalf of Secretary of State Jocelyn Benson. Your Honor, the Secretary takes her role as the state's Chief Elections Officer very seriously, and it is her duty to ensure that Michigan elections are conducted in accordance with the laws of the state and in a manner that preserves the integrity of that process. But the question here, and she does not dispute that allowing an ineligible or unqualified candidate on the ballot tends to undermine both the integrity and the efficacy of that process. But the question here is who has the authority to determine whether a candidate for the office of President of the United States has engaged in insurrection such that he should be disqualified from either seeking or holding that office under Section 3 of the 14th Amendment. Michigan law, indeed the Michigan legislature, has not accorded the Secretary the specific authority to make that constitutional determination. Now, to be clear, the Secretary stands ready to comply with whatever order this court issues in relation to the former president's eligibility to appear on the ballot. But otherwise, the Secretary has no formal position, as you saw from our briefing, on the many constitutional questions presented, not only in Mr. Davis's case, but the remaining cases. Before turning to Mr. Davis's complaint and his claims, I want to just note a matter of timing. Your Honor has acted expeditiously in processing.
I feel truly that it hasn't been nearly expeditiously enough.
You have been.
Right. I really do feel badly it's taken this long, but at any rate, it is what it is.
It's going, but so I think perhaps you've read the papers. I think it's probably fairly well understood for those of us interested in the issue that the legislature does intend to adjourn in time to make the primary date move to February 27th.
What is your understanding, counsel, of, and I could, even when I was worked in Lansing briefly for 4 years, I could never pronounce the sine die. What's the pronunciation of it, do you know? How about Mr. Brewer?
I say sine die, but
sine die, that's it, sine
die.
That's what it is. Okay, so sine die, has it been officially stated by either the speaker or the Senate Majority Leader? And I know Mr. Davis asked to have them testify here today, and I respectfully denied his motion, understanding this was not for evidence sake. But do you know what the situation is?
I'm not sure that it's been an official date. I mean, what have I read in the paper? I mean, like you're reading in the papers too.
I'm sure there's no hearsay.
Not official until it's official, but right. I believe there is every specific, every intent or every indicator that they intend to adjourn next week sometime, which would be with sufficient time to make the presidential primary date move to the 27th. So if it doesn't, we can talk about what the dates would be differently. It doesn't really matter. Your timeline is
It seems
tight.
that the 90 days on the issue for the 27 February 2024 presidential primary, my recollection of looking at the calendar was it was around November 27th or 26th that the legislature had to have sine die take place for the 90-day period.
Yes, that's my understanding as well.
And
but
today's the 9th, tomorrow's the 10th of November. So, okay. So if that happens, then those issues become moot.
That's correct, Your Honor. The claims in Mr. Davis's complaint, those are counts 1 and 2 on the primary date. I think, it would be moot by then. The point I was trying to make right early before I forget, before we maybe not get to it, is what kind of speedy timeline we're on to resolve, the issues in this case if the court intends to affect the primary ballot. So if we have a February 27th primary, as the court probably knows, the state must be able to send out military overseas ballots 45 days in advance of the primary date. So that kind of moves us back to January 13th, I believe, is our 45 days.
When I look at the window, to me, it's this, and I fully recognize I am not the last word on whatever happens in this case. maybe, but I think it'd be the first time I'm ever the last word on anything of this substance. So the appellate tribunals, either the Court of Appeals or the Supreme Court of the state, we've got to have a decision by, I think, January 10th. There are 177,000 forward deployed troops serving outside of the United States right now. One of my children just came back from deployment. I was myself served overseas multiple years, and it's important that those service members and their families receive their ballots. So I recognize that whatever happens in these cases, this one and 137 and 151, it will happen relatively quickly. It won't happen today or this afternoon. I'm not ruling from the bench, but I hope to rule quickly.
Right. Respectfully, with respect to the January 10th, I think because we need to be printing ballots most likely around that time. So we're
Okay.
really, really tight time.
So you
frame.
think it's probably January 1st? Give or take.
And that would be, all the way through the appellate courts.
Yeah, oh yeah.
Yeah, so, all right, it sounds like we're on the same page, Your Honor, and you fully appreciate the tight timeline that we're on.
As I say, that's why I feel terrible that I haven't had this.
Well, it's a very fluid situation with all of the other cases moving through the courts in the other states, so it's been interesting. All right, so turning to Mr. Davis's complaint, we did file a partial motion for summary disposition, but we only moved on counts 1 and 2 and some of the counts where he didn't seek expedited relief. So counts 1 and 2 are the primary question, which I think we've already talked about. By the time the court gets around to maybe writing an opinion or order on our MSD on that, we'll know what the actual date of the primary is. So I would expect it's going to probably be moot by the time you're writing an order, but if it's not, it's controlled by the Constitution and it will be whatever date, is 90 days from saying that. So, and whatever is effective at that time will be the time that we hold the primary. So on the counts 3 and 4, which we didn't move on, those are the counts. Count 3 asks this court to declare that it's the Secretary's duty to make a determination as to whether Mr. Trump is disqualified under the 14th Amendment. And count 4 was a follow-up to that, essentially mandamus to compel us to undertake that review. So as we've explained in our briefing, really 3 times over in the cases, Your Honor, the law simply doesn't allow the Secretary or provide the Secretary with any authority to investigate or delve into the qualifications or lack of qualifications of a presidential primary.
Do you think it's
candidate.
Exclusively as to a presidential primary candidate or others? And I specifically, I'm thinking about MCL 168.614A, 615A, 615C, and whether or not that proscription of the Secretary to be able to investigate or determine, does that apply to other candidates for office?
With respect to other,
or does it matter? Yeah.
Well, I think the answer is very clear with respect to presidential primary candidates. What's different about other candidates, even other federal candidates, like, representative in Congress or senator, with respect to other candidates, the legislature has specifically imported into the election law the qualifications requirements. So if you go and look for U.S. Senator in the right statutes, you'll see that the qualifications, the eligibility of the qualifications have been imported from the federal Constitution into our Michigan election law. So they've incorporated it there. And then also with respect to the other candidates, but not presidential primary candidates, the legislature has required candidates to fill out an affidavit of identity before they can gain ballot access. And in that affidavit, it requires the candidate to affirm that they possess the statutory and constitutional qualifications, for that office. And that's notarized and you affirm it. And if there's a false statement in it, it is punishable by a misdemeanor.
And my understanding under the 615 series of statutes, tomorrow at 4 p.m., the Secretary will have had to notify the chairs of the state parties that receive more than 5% of the president of the ballot votes in the last quadrennial election will receive a list from the secretary of individuals that the secretary believes identified by national media are candidates for the presidency for their party. And then on Tuesday next, November 14th this year, the dates are not listed in the statute, but it says the second Friday and then the Tuesday after the second Friday at 4:00 p.m., the chair of the parties will notify the secretary whether or not they're in agreement, and that if they are, then the secretary is going to, or if there's no dispute between the secretary and the parties, then the secretary under the statute will send notice to a candidate, and unless they take an affirmative act to do otherwise, they will appear on the primary ballot. Is that your understanding?
I think that's mostly correct, Your Honor.
What part did I get wrong?
Well, I'm not sure about the interactions between the parties and the agreeing upon, right? There's not an agreement upon the slates between the secretary and the parties, right? So if you look at 614A, right, sub 1 and sub 2, sub 1 is the section that requires the Secretary of State to compile her list, her slate of candidates based on, those generally advocated as potential candidates by national news media.
Right.
So the court noted that would be generally tomorrow, the Friday. However, tomorrow is a holiday.
Okay.
So we're bumping that to Monday because the election law does have a section that says if there's a date certain that ends on a holiday.
Sounds like the court rules.
It does sound like the court, because it is just like the court
And I've
rules.
had that in my other job as a Court of Appeals judge, which after 5 years, I'd kind of gotten accustomed to being on the Court of Appeals. It's such an amazing privilege to be able to serve there. And now being back in the trial court, it's a different wheelhouse for me. And I'm trying to remember how to do both jobs. So, okay, so the deadline is not tomorrow, it's Monday.
The deadline is tomorrow, but by operation of the statute, right, it would push it to Monday. So we do plan on issuing the list on Monday. My understanding from speaking with Bureau of Elections folks is I do believe that we plan to let the parties know that today, that the list will be coming on Monday and not tomorrow.
Okay.
So that they'll be aware of that. But then the deadline for the parties, so under subsection 2 of the 614A, that's where the major political parties, submit their slate, right? And that can be whoever they want. It doesn't have to match our list at all, right? So they submit their slate under subsection 2, and that does still come next Tuesday. That date's not moved. It's not a holiday.
Okay.
So we'll have the list coming out Monday and Tuesday of next week.
Yes.
And really, and as you indicated in section 615A, essentially it's unless somebody intends to withdraw, unless a candidate notifies that they intend to withdraw, those lists just simply go, by operation law, that is your slate. Like those are the candidates. There's no stopping. The only change that happens if somebody withdraws.
Okay. All right.
I think we were talking about the ability, the qualifications and determining eligibility of the candidates, Your Honor.
Right,
We had started talking
because
about
there's
affidavit identity.
there's the specific carve out, at least it appears to the court, for the presidential primary as opposed to other specific offices. And you briefed this in multiple, filings in this case. So did this in other cases.
Right. I think the section 558, which is the affidavit of identity requirement, sort of drives that home, where the legislature specifically exempted the candidates for president and vice president from the affidavit requirement. The only spot where essentially they could be called to affirm their qualifications for office, and that specific carve out, I think, really drives home that the legislature does not, did not expect, anticipate, want, a delving into the qualifications of the presidential primary candidates. That really, the primary is really sort of serves a function. It is for the parties, right? It really isn't for the secretary. It
Well,
isn't for
in the
state.
opinion from the Minnesota Supreme Court, which is obviously not binding on this court, I'm sure they're brilliant jurists in Minnesota. I'm sure it's an outstanding court, but in the order that I saw yesterday evening, they seem to say that very thing. Said this is a party function. It's not a Secretary of State function, so you can't get the relief you're seeking.
I thought the order, I think is accurate to a lot of how the same things, the primary functions here. It really is.
Yeah, I haven't pulled the Minnesota statute, but it certainly sounded very
I
similar.
didn't either, but it's my, reading my cases and being experienced in the election law, it's really the similar type of function for here, here it's the primary serves as sort of like a bellwether or test case for the parties where public opinions, where there's sort of support. But then really at the end of the day, as we pointed out in the statutes, that may not be the winner of the primaries, may not be who's on in November, right? So ultimately, it really is a party function as to who appears on the November general election ballot.
I have a historical question. Do you know how long have states conducted presidential primary elections?
But Mr. Brewer you could ask him that question.
We have
His
we have one counsel who's going to be appearing later, so he's taking notes. He's going to sort out. But because it is and then ultimately it's the convention that selects the party's candidate.
And generally, there's a matching, right? The winner of the primary is who ends up on November, but it's not required.
I don't know. So, okay.
I think if the court, understands our position on that it's not the secretary's role to make a determination regarding the 14th Amendment issue with respect to Mr. Trump, I'm not sure that I have much to offer. And we submitted briefing. We tried to be helpful on some of these other issues, but you've had a plethora of excellent briefing that takes affirmative positions on both sides of those. So.
I do have a question on the 14th Amendment and the secretary not being the party to call the first ball and strike, if you will. I'm reminded of the adage, if not them, then who? And if not now, when?
Well, the who, I think, is you.
Oh, okay.
Well, right. I mean, there just simply is we have no administrative process. We have no process for conducting any kind of inquiry or investigation into something like this. The secretary doesn't have any subpoena power. It's just simply not there. The legislature hasn't, provided us with any kind of administrative vehicle. So then I think the only other vehicle is what you've seen before is the actions that we have before you, which are declaratory judgment actions, asking with respect to not necessarily Mr. Davis, because he's still seeking a declaration that it's our job. But, as you've seen in the LeBrant case, they're seeking a declaration. They want you to declare that Mr. Trump is ineligible. And I think
Does the secretary have any position on justiciability?
Justiciability. Badly brief both sides of that issue, I believe, in our response to Mr. Trump's, the memorandum we filed in the Trump case. So no, we don't have a position on that. I think that's consistent with the secretary's, articulation in her Washington Post op-ed piece that these are all significant legal questions with good arguments on both sides, Your Honor.
Okay. All right. And do you have anything else before I just review my notes real quick?
I don't think so, unless the court has any other questions.
Let me just take a quick look. I'm sorry, if you'll have an opportunity to speak. Thank you. All right, council, thank you so much.
Thank you, Your Honor.
And you have you have the time necessary to respond. Mr. Davis, be happy to hear what you would like to share with the court. Thank you.
I have a number of things to address.
Please proceed when you're ready.
First, to address counts 1 and 2, which are the same in both the original complaint and the amended complaint.
Yes, sir.
And counts 1 and 2 pertains to the date, the proper date of the 2024 presidential primary election here in Michigan,
Right.
whether it's going to be in February or whether in March, as the current existing statute requires. Contrary to the arguments made by Ms. Mingus, the deadline for Public Act 2 2023 to go into effect has passed. Even if they adjourn, as I was advised this week by some state legislatures, because their arms were being twisted by the Secretary of State's lobbyists to adjourn this week.
Okay, let's stay focused on
Indeed.
as opposed to, I can't imagine in Lansing there would ever be any arm twisting of anyone, but let's just stick to the legal arguments.
Absolutely, Your Honor.
Thank you, Mr. Davis.
In which, whether they adjourn this week or next week,
Okay,
that ship has sailed. You know why, Your Honor?
I don't, and I'm very curious to know.
Based upon one of your most recent opinions, in which involved the same two parties, myself and the Secretary of State, it's the date in which these ballots have to be printed, whether it be for the March election or for February. And as the Secretary has conceded in her briefing, is that that decision is not left with the Secretary of State as to when the ballots are authorized to be printed. That decision is left solely to the county election commissions. And so that you know, Your Honor, we have to go based upon existing law, not law that may become in effect 3 months from now, but existing law. The Wayne County Election Commission, which is the largest county of this great state, has indicated that the Wayne County Election Commission, which I'm involved in litigation with, along with Mr. Trump, which I'm going to address as well, because you hit the nail on the head. If not the Secretary of State, then who? You're going to get an answer to that question. They're going to convene in December based upon existing law that they're bound to follow.
Right, but
And the
what is your understanding, Mr. Davis?
My understanding.
Hold on.
Okay,
Let me ask a question.
Sure.
What is your understanding of the principle of law as in Michigan that if a legislative body passes a statute and gives it to the governor for signature, and it's either signed or it's vetoed, and then the veto is overridden, but it's not given immediate effect because 2/3 vote wasn't garnered from both houses to give it immediate effect, or wasn't part of the whatever. It doesn't have immediate effect. Just like this changed the date of the primary statute did not have immediate effect. What is your understanding or your position of that once the legislative body recesses that passed that statute, that it becomes a law after 90 days?
It cannot become operational per the holding in the advisory opinion from our Michigan Supreme Court. It's not operational until the 91st day. So the Secretary, what the Secretary of State is attempting to do is say, just say, assuming arguendo, they adjourn today.
Okay.
The Secretary of State's position is that we're going to begin to enforce it and put it into operation right now because they have adjourned today. Even though the Supreme Court has said, no, you cannot, that statute cannot become operational until the 91st day after the adjournment.
What's the site for the case you stand for that
Is
proposition?
In re request for advisory opinion regarding constitutionality of 2005 PA 71. The citation is 479 Mish 1 at page 12, 2007 case from our Michigan Supreme Court. They're attempting to make Public Act 2 operational from the date in which the legislature adjourned. The Michigan Supreme Court said, no, you cannot do that.
How are they? Aren't they trying to prepare for a change in the law, which is, let's assume, for purposes of our discussion, that the legislature adjourns sometime between now and a period in which 90 days will pass before we get to February 27th, okay? If that happens, why, on February 27th, 2004, the effective statutes of Michigan will say the primary election in 2000, or did I say 2004? I'm going in the Wayback Machine. In 2024 will be 27 February, right?
Here's why, Your Honor.
Okay.
It's because the ballots have to be printed well in advance of Public Act 2 going into effect and becoming operational. So for instance, when the Wayne County Election Commission convened—
I do understand that.
Yeah,
I understand all
when-
that. But why is it ultra vires for a executive branch agency, whether it be the Wayne County Election Commission or the Secretary of State, to make and then execute plans in compliance with the statute they know is going to be in effect?
Because I'm glad, that's a great question, Your Honor. And I'm glad our Supreme Court has addressed it in the case that I just cited and in another case. Our elected officials are bound by existing state law in effect at the time in which they make a decision. So if the Wayne County Election Commission and all the other county election commissions did not have to authorize the printing of the presidential primary election ballots prior to Public Act 2 going into effect, Secretary of State would be on great solid legal ground. However, when they have to execute and convene as a public body and authorize the printing of the ballots, which includes the date of the election, guess what law is in effect at that time? The existing law right now that makes
Right,
it
but
March
the
27th.
law that's in effect on the date that those ballots are going to be counted is 27 February 2024.
But the problem here, Your Honor, is that if you allow the Wayne County Election Commission to ignore existing
I don't have
law—
that case, do I?
Oh, no, you don't have that
okay,
case.
all right,
You're-
good.
But I'm just letting you know what's also on the runway, because that's the
Right.
answer to one of your subsequent questions, is that if not the Secretary of State, then who?
Right.
Which I will address later. But those questions involving the Wayne County Election Commission is not before this court, as this court doesn't even have jurisdiction of that party. But in order for the Secretary of State's position to prevail, this court would have to say that the election commissions all across the state would have to ignore existing law in order to print the ballots with a date for a future election in which legislation will go into effect at a later date. That's the problem. They're trying to make this law, Public Act 2 of 2023, operational before it goes into effect. That's why the ship has sailed. The legislature would have had to adjourn back in September based upon the fact that the election commissions all across the state of various counties are going to have to convene in December in order to authorize the printing of the ballots by the deadline in January, be it for the March election or the February election. And that's one thing which the Secretary didn't account for, It's not when Public Act 2 goes into effect, because you have all of these other statutory deadlines that are unaffected by the new legislation.
Are they statutory deadlines, or are they deadlines in effect because of promulgated rules under the APA? Or, so three-part question, or are they deadlines that are in effect because of the custom, practice, and habits, if you will, of those who have the duty to administer elections?
They're statutory deadlines. And these are the same.
What's the statutory deadline you're referring to?
I believe the secretary very poignantly pointed out in her brief those deadlines. And if I can bring to your attention, because I would like to state, Your Honor, the Secretary of State uses those deadlines in order to argue latches in election-related matters, to say it's too late based upon those statutory deadlines as to when the overseas ballots, as well as the time period in which an elector such as myself has the right to request an absentee ballot application within 60 days prior to a date of the election. So all of these are all statutory deadlines, and the Secretary did a very great job of outlining each of those statutory deadlines in terms of the overseas ballots. And if I can take a minute to give you the page. Heather, do you know the page that you?
Okay, hold on a minute, please. You each have a binder. Everybody has a 3-ring binder. So, what page, Council?
It's the Secretary's Memorandum of Law, is page 4 and 5.
Thank you. My travel briefcase has become literally a carry-on suitcase, which is a privilege to have so much wonderful information.
And I appreciate the Secretary's Counsel's candor in pointing out those statutory deadlines, which are unaffected with the enactment of Public Act 2 of 2023. And that's one thing in which the Secretary failed to take into account, is that the county election commissions, which under MCL 168.689 statutorily is the only body with the authority to approve the printing of the ballots for this election, Your Honor. They're under a duty to approve the printing of the ballots by these statutory deadlines. And in order to achieve that, the largest county has already indicated they're going to have to convene in December, whether it's...
Okay, right, but I do understand that, you know, but if the, I mean, the one thing that we all have the same is we each have 60 seconds in every minute, 60 minutes in every hour, and 24 hours in every day. So I think we can all agree on how many days of the calendar are going to expire between X and Y. And if there's 90 days that expire between when the legislature of the state of Michigan goes into sine die and February 27th, 2024, I'm still, I know I'm going to have to read this case, the 479 Michigan one, but I'm having a little trouble tracking on why an election commission of a county, be it Wayne, Kent, or Crawford, or any of the other 78 counties in Michigan remaining, why is it a violation of the law for them to print this ballot on a date that the legislature has said, for the date that the legislature has said is going to be the presidential primary?
Very simple, Your Honor. Our Supreme Court said that law is not operational until it goes into effect. It's just that simple. Public Act 2 is not operational until the 91st day. You're attempting to make it operational from the date in which the legislature. No, I'm sorry, Your Honor.
I'm trying to.
I'm sorry.
No,
I'm sorry.
I'm trying to sort out.
Yeah. It's the word, that's the reason why it's important to give legislation immediate effect. So that legislation.
Any of us who have been around Lansing would agree with that proposition. However.
And so because the legislature didn't give it immediate effect, the secretary cannot circumvent the Constitution.
Okay.
It's operational. When does that legislation become operational? And in order for the secretary to get her way, it would require this court to say, disregard existing law and make Public Act 2 operational now and not on the date in which, not on the 91st date.
All right. Interesting. Okay, I think I understand your position on that part.
Thank you, Your Honor. The next argument, Your Honor.
And you're about halfway through, just for no, I'm not. There's not to apologize. I know back 1,000 years ago when I would make oral arguments, when the judge said, "You have 2 minutes left," I'd be like, "There's no way I took all that." So you're at
the halfway.
You're at the halfway point, roughly. So.
And with respect to counts 3 and 4, I'm going to refer back to your statement. If not the Secretary of State, then who? And very humbly, Ms. Meingas indicated this honorable court should be the initial determiner. And I respectfully disagree.
How does the Secretary have the capacity to do it? And first question.
This is no different when they're confronted with a candidate that submitted a false affidavit. It's no different. They have to go beyond the face of the affidavit to ascertain whether or not any statements in that affidavit of identity was false. So by way of example, Your Honor, if a candidate, a judicial candidate, I mean, that's recent, a judicial candidate submitted an affidavit of identity attesting to the fact that they've submitted all of their campaign finance reports, it would require the Secretary of State to look through her records to see whether or not, or whatever information has been provided, whether or not that candidate swore truthfully. It's no different. Based upon the information submitted to the Secretary of State, the Secretary of State can ascertain, based upon the evidence submitted, whether or not there's credible evidence to the argument. Both sides. And no matter what election, and Ms. Meingas.
Yeah, at some point, I very much appreciate your insights on the statutory carve out, if you will, of presidential primaries. But I'm interrupting.
No, I'm glad, because that's the reason why I brought up, just to be full transparent, the issue in Wayne County right now. Because if the court turns its attention to MCL 168.689,
the older I get, the easier it is for me to read from books as it is to the 6-inch computer screen. So, okay. Yes, I'm there.
once those lists are compiled by the Secretary of State and the respective chairs of the political parties, and the deadline has passed for candidates to submit petitions who are not not candidates for the major political parties.
Mm-hmm.
Secretary of State, as she's admitted in her briefing, that the lists are then submitted to the various county election commissions who are governed by.
Also, did you say 869?
689, 168.689.
Because just 869 is about recounts. I'm
Oh,
thinking
no.
We're sort of, that's a little ahead of the process, aren't we?
689.
689, sorry. I'm sure I misheard you. Okay. Board of Elections, got it.
168.689 provides the statutory legal duties of the County Election Commission once they receive the list of certified candidates. They then have to determine themselves if those candidates were properly certified by the certifying officer, and in this case, the Secretary of State. And I bring that to the court's attention because if this court were to disagree with my legal arguments that she has the initial authority under Article 11, Section 1 of the Michigan Constitution, as well as under Michigan Election Law 168.31, to make a determination as to whether or not any presidential candidate meets the qualifications, then certainly under MCL 168.689, as interpreted by a court of appeals in a published decision of SMFBC versus Killeen, a 1986 case, which has been cited repeatedly.
What's the site?
I don't have the exact, I just
Okay.
remember the
Okay.
the name of the case.
1986,
It's a 1986 case,
SMF v. Killeen.
SMFBC versus Killeen, which involved the Wayne County Election Commission. The Court of Appeals interpreted that particular section of Michigan election law to mean that each election commission has a statutory legal duty to make an independent determination as to whether or not candidates certified to them by the certifying officer were indeed properly certified. And they interpreted what properly certified meant. And that means, did they meet the qualifications to appear on the ballot?
Okay.
So if this court were to determine that the Secretary of State does not have the initial authority to make that determination, and per the carve out for presidential primaries, that once she submits that list to the various election commissions of each county, guess what? They're going to be presented the same challenges she was presented.
Let me have a moment, please. Sure. Somehow a pen has literally exploded in my hands. So I've got the ink absolutely everywhere. The things that happen when we're in trial.
And
So, all right, but why, you've had a chance to review the order from the Minnesota Supreme Court.
absolutely.
So why do you do you disagree or do you agree with them?
Well, the Minnesota Supreme Court ruled on Minnesota state law.
Right, which I haven't read it, but it
Yeah.
looked an awful lot like what Michigan law is.
And notably absent from their decision, which is why I believe they dismissed it without prejudice for obvious reasons. None of the arguments in which Mr. Trump has presented to this court on the federal issues were the basis for their denial. It was based solely upon state law. And as I read our state law and the duties of our Secretary of State, and I would love for this court to revisit its opinion in Davis versus Benson from 2020, in which this honorable court was the author of the published opinion dealing with the absentee ballot application issue, in which this court, in its legal analysis, examined what the duties are of the chief election officer of the state. And if this court looks to MCL 168.31, parent then 1, subsection H, small h, It gives the Secretary of State statutory legal authority to investigate the proper administration of the election laws of the state. Under our Constitution, Article 11, Section 1, she was administered an oath of office in which she swore to uphold and to support both our state constitution and our United States Constitution. Certainly, one cannot be upholding the federal Constitution if they permit a candidate who is otherwise ineligible under the United States Constitution. By way of example, Your Honor, if the Secretary's interpretation of the carve-out is correct.
Sure. Stop you real quick. You have about 5 minutes left. So if you want to talk about any of the 14th Amendment
Oh, no.
substantive stuff.
I leave that to Mr. Brewer. What I want to make clear, if her interpretation of the carve-out is correct, then nothing would prevent a state party chair from submitting the name of a person who's 21 years of age.
All right. And then they would be ineligible for office.
They would be, but under her reading,
Would they be ineligible for office?
yeah, but under her.
Okay, so, and then under the 23rd or the 25th Amendment, then they don't get to serve.
But under the Secretary's interpretation, she would have to accept that person's name
Mhm.
and submit it to have his or her name printed on the ballot. Now, logically, does that make sense? And that's no different than the circumstances that we have here, where you have allegations and documentary evidence to suggest that a person doesn't meet a particular qualification as set forth under the United States Constitution for that particular office.
In the 20th Amendment, Section 3, it talks about when a president-elect fails to qualify and the steps will be taken when that takes place. And then the 22nd Amendment, 23rd Amendment, and 25th Amendment, particularly the 25th, talks about the succession of the presidency. I think you're right as far as that if the secretary's position is taken to its logical conclusion, if the state party says we want Jim Redford as our candidate, and Jim Redford's 22 years old, that the secretary puts Jim Redford on and wins, and then somehow, but okay, how is that unlawful?
That's unlawful, Your Honor, because for one, that candidate obviously doesn't meet the qualifications of that office. Number two, under the precedent established by our Court of Appeals in the published decision of Barrow versus Detroit Election Commission is very clear. Our electorate, the Michigan voters, expect those candidates that appear on the ballot meet the qualifications for that particular office. That's the expectation. And certainly, as cited in the briefing, there is no constitutional right to run for office, and there is no constitutional right of a voter to vote for an otherwise unqualified candidate. And so,
Right, but in this single circumstance of a partisan primary, how has the legislature not made the decision that the party is able to make this determination?
under Michigan law, Your Honor, it
Can't. Your position is they just can't do it. It's illegal.
That's
So do you want me to declare that statute's unconstitutional?
well, if that's the position of this court, that you believe that statute is unconstitutional.
No. Well, good response, Mr. Dave. That
But-
was an excellent response.
But Your Honor, the reason why I highlight the fact of what 168.689 states is that although the Secretary of State is the chief elections officer, she's not the final say as it relates to the printing of the ballots and whose names appear.
I think that's an excellent point. So you have
And-
right around a minute left.
And for the last 60 seconds, Your Honor, I would like to address count 6.
Mhm.
And count 6, once again, pertains to the Secretary's noncompliance with existing state law. I pointed out to the court that their initial argument was, we've submitted proposed rules. Well, the proposed rules that they submitted didn't comply with the new published opinion of the Court of Appeals that says the promulgated rules have to have certain mandatory information. And so those proposed rules that they've submitted are dead on arrival because they don't comply with the APA. So once again, Your Honor, the Secretary of State has failed to comply with state statute that says she had to properly promulgate rules in accordance with the APA to enforce MCL 168.759 small a parent then 17. That has not been done. And then in her subsequent briefing, realizing the huge error that they've committed based upon new precedents established by the Court of Appeals, their new argument is—
Was that the opinion, Judge Godola?
yes.
Okay.
Their new argument is Senate Bill 470 will go into effect sometime in the next few months. So it renders this action moot. It does not. Because once again, Your Honor, this court, as well as the elected officials, have to enforce the law that is currently in existence. And the current law requires her to promulgate rules properly in accordance with the APA by January 1st, which has not occurred.
All right. Mr. Davis, thank you for your submissions in writing, and thank you for your very thoughtful and well-presented oral position today as well.
Thank you.
You're welcome. Counsel, is everybody, you okay to keep going?
Yes.
All right. Before we start, I'm going to take that. I was for 5 years a judge in the Navy Marine Corps trial judiciary, and we'd stand and stretch. So I'm going to stand and stretch. If anybody else wants to, before we continue to our next 30 minutes or less of oral summation. Okay. Everybody ready? Dan? Mike? All right. Thank you. All right.
Good morning, Your Honor. Michael Colombo on behalf of Amici Donald Trump. I'd like to speak today on issues relevant primarily to counts 3 and 4 of the plaintiff's amended complaint. In sum, the Secretary of State does not have the power that plaintiff claims and has acknowledged as much. The political question doctrine also counsels against the Secretary of State exercising such power, and the plaintiff's requests in counts 3 and 4 must therefore be denied. In count 3, the plaintiff requested a declaratory judgment that the Secretary of State has a duty. Yes, ma'am. Yes, ma'am.
Thank you, ma'am.
Declaratory judgment that the Secretary of State has a duty imposed by the Michigan Constitution and Michigan case law to determine whether a presidential candidate is disqualified by the United States Constitution from campaigning for election to the presidency, and if so, to remove his name from the Michigan ballots. Relatedly, in count 4, the plaintiff asked this court, through a writ of mandamus, to compel the Secretary of State to fulfill that duty by adjudicating plaintiff's allegation that the Constitution disqualifies my client from running for office. This case and others like it demand reading the law as a whole and interpreting the parts in ways that let the system work. We have to avoid inadvertently creating a crisis that an otherwise blinkered approach might cause. Plaintiff's interpretation of the law would empower a state election official, even an elected one, to remove a presidential candidate from the ballot of a political party's primary election.
Right, and the argument is the person should be removed because they're not qualified under the United States Constitution for the reasons cited by other amici, but also by Mr. Davis and Mr. Brewer in case 137.
Yes. And there's a reason why that interpretation has to be wrong. There's a lot of different parts of this that we can skip to. I'll just quickly say that if this interpretation is, if Mr. Davis's interpretation is correct, it would deny voters the opportunity to vote for a candidate of their choice, deny the parties the
Right,
nominees
but
of their
do you
choice.
agree that there's not a constitutional right to vote for a specific candidate?
I think in this context, the framework should be the right of the party as an association of voters to choose a nominee of their choice.
That's very different from what you just said. Now you're talking about a First Amendment freedom of association
Well, yeah,
argument as opposed to a person who has a constitutional right to vote for a certain individual.
well, I guess my comment is that allowing a state secretary or other agency to disqualify a candidate from even running has an impact beyond the state. And it has an impact.
Don't disagree with that.
Yeah, and I'll,
Is that a power that they have?
no, it's not.
Why not?
Under Michigan law, there's no such power, and under federal law, there's no such power. Under Michigan law, we agree with Secretary of State's position that in our filings with this court and oral statements a moment ago, that Michigan simply does not empower the Secretary of State to adjudicate or investigate an allegation of Section 3 disqualification. As summarized on page 1 of their brief.
Then why shouldn't the court decide it?
The beyond Michigan law not authorizing the Secretary of State to have that power under Michigan law, there's also a federal constraint. And that is one of them, at least, is the political question doctrine. The political question doctrine set out by the United States Supreme Court includes, the United States Supreme Court set out broad categories of things that should be considered non-justiciable political questions in Baker versus Carr, which, according to Mikowski versus Governor, also informs analysis in Michigan courts. The plaintiff would have the Secretary of State independently judge the qualification of federal candidates. Whether the Secretary of State must set up a court-like program for complaints or just do it on its own initiative for every candidate or select a candidate is unclear. In any event, federal and state courts presented with challenges to the qualifications of presidential candidates have overwhelmingly held that they present non-justiciable political questions that the Constitution reserves for Congress and the voters. These cases take into account consideration of comity, the deference due to federal law under the Constitution's Supremacy Clause. Accordingly, in Granoll's versus Electoral College, which we cite in a brief, the Eastern District of California held that the Constitution assigns to Congress and not to federal courts the responsibility of determining whether a person is qualified to serve as President of the United States. And in that case, the question was whether President Obama may legitimately run for office and serve as president, which the court determined is a political question that the court may not answer. In Tights versus Democrat Party of Mississippi, the Southern District of Mississippi similarly held the presidential electoral and qualification process are entrusted to the care of the United States Congress, and that plaintiff's disqualification claims are therefore non-justiciable. And in Robinson versus Bowen, the Northern District of California dismissed a case brought before the 2008 election seeking to remove Senator McCain from the ballot. It held, yes, ma'am.
Like you're not reading.
In Robinson versus Bowen, the Northern District of California dismissed a case brought before the 2008 election that sought to remove Senator McCain from the ballot. The court held it is clear that mechanisms exist under the 12th Amendment, 3 U.S. Code, Section 15, for any challenge to candidates to be ventilated when electoral votes are counted, and that the 20th Amendment provides guidance regarding how to proceed if a president-elect shall have failed to qualify. Issues regarding qualifications for president are quintessentially suited to the foregoing process. Arguments concerning qualifications or lack thereof can be laid before the voting public before the election, and once the election is over, can be raised as objections as the electoral college votes are counted in Congress. Judicial review, if any, should recur only after the electoral and congressional processes have run their course. There are other doctrines which we address in our brief as well as to whether or not In particular, Section 3 is self-executing, whether it applies to presidents, whether states can transform a Section 3 disqualification into a ballot access qualification. If any of those things are in particular of interest to the court, I'd be happy to address them.
It's your opportunity for addressing the positions that you think are most relevant. I don't have particular questions on that that but please proceed.
Well, the Section 3 of the 14th Amendment is not a self-executing provision. That is, the Secretary of State or the state as a whole has not been given power by Congress to enforce it. First, the plain language of the 14th Amendment states in Section 5 that the Congress shall have the power to enforce by appropriate legislation the provisions of this article. Note also that the distinction made in the Blackmun and Stillman article we cite between the offensive use of a constitutional provision, which requires implementing legislation, like Section 1983, versus the defensive use of a constitutional provision, which does not. Section 5's command, Section 5 of the 14th Amendment, its command that Congress can enforce Section 3 with legislation, and Congress's enactment of such legislation for a time is consistent with their analysis.
Right, but since Congress did enact certain legislation under Section 3 in the 1870s, why is it not on the table, shall we say?
Well, it's Congress's power and Congress's prerogative to decide how it would go about enforcing Section 3. There was a period of time where they had an enforcement act that allowed federal attorneys to enforce Section 3. There came a point in time where Congress apparently felt that was no longer necessary, and at least by, the latest, it would be 1948 or so, Congress took that legislation off the books. There was discussion just 2 years ago about whether to create new enforcement legislation for Section 3, but ultimately Congress did not do so. It is Congress's power in the Constitution. They have the ability to delegate it. For a time, they did create an enforcement mechanism. Right now, there isn't one that allows a private cause of action. Accordingly, the power to enforce Section 3 currently resides in Congress alone, and therefore this court should deny plaintiff's request for this court to order the Secretary of State or for this court to enforce Section 3. Additionally, Your Honor, a question that you had concerned the difference between holding office and running for office. States are prohibited from enacting additional qualifications for federal office in the guise of ballot access restrictions. Section 3, by its plain terms, states that a disqualification for holding office, not running for office. Courts have found that states have not been delegated authority to create their own state-based additional qualifications for president. As we note in our brief, candidates may and have been elected while still not qualified to assume office, and then assume the office once the qualification is satisfied. Accordingly, Joe Biden could and did run for Senate when he was 29, even though the Constitution says that senators must be 30 years old. But even a person disqualified by Section 3 from holding office could have their Section 3 disability removed after the election. Section 3 itself says that, quote, Congress may, by a vote of 2/3 of each house, remove such disability.
What's the impact of that? The 2/3, the removal of disability clause.
Well, in addition to the 14th Amendment providing a disqualification and Section 5 saying Congress may create legislation to enforce it, it also gives Congress the power to remove that disability. So it would be premature under this framework for states to remove people from the ballot before Congress may have an opportunity to lift their disabilities. In our brief, we cite 3 cases, Smith versus Moore, Privet versus Bickford, and Sublet versus Bedwell, which in the 1870s and 1880s held that persons disqualified by Section 3 could indeed be elected, but could not assume office until their disqualification was removed. This is consistent with the holding in Robinson versus Bowen, which we cite, a case seeking to remove Senator McCain from the ballot in 2008. The court there opined that challenges to candidates must be aired and that electoral votes are counted. The 20th Amendment provides guidance on how to proceed if a president is in fact disqualified.
I have a question.
Yes, sir.
On February 19th, 1866, the congressional record seems to suggest that a joint resolution was introduced, which is the first discussion of the 14th Amendment, Section 3, what becomes it. The language used by Congress that day was no person shall be qualified or shall hold the office of President or Vice President of the United States, Senator, Representative in the National Congress, or any office now held under appointment from the President of the United States, and requiring the confirmation of the Senate, who has been or shall hereafter be engaged in an armed conspiracy or rebellion against the government of the United States, or who has held or shall hereafter hold any office, either civil or military, or under any pretend government or conspiracy set up within the same, or who has voluntarily aided, or who shall hereafter voluntarily aid, abet, or encourage any conspiracy or rebellion against the government of the United States. Section 3 of the 14th Amendment, as transmitted from Congress on June 13th, 1866, had different language. Is there any moment to any of the difference?
In that quote, the part that is drawing your honor's attention, is it?
I'm asking if there's any difference. I'm not going to say, here's what I'm really, what I'd like to, I've just told you what was in the congressional record.
Right.
And that was proposed on, or submitted on February 19th, 1866. The final language was sent to the states on June 13th, 1866. So roughly 4 months later. The language is different. It was sent to the states and was ratified. Does it matter?
Your Honor, I think our first step in the analysis has to be the words that we have.
Okay. Why doesn't it apply to the president? From your perspective?
Yes. Section 3 applies to those.
I'm pretty sure people who are on the opposite side of this issue may feel a little differently than you, but go ahead.
Certainly. Section 3 applies to those, quote, who, having previously taken an oath as a member of Congress or as an officer of the United States, or as a member of any state legislature, or as an executive or judicial officer of any state to support the Constitution of the United States. This list plainly doesn't include the title of president, though it would have been easy for Congress to include that word in the list. We recommend to the court the Republican National Committee's amicus brief, which deals at length with this question and with some sophistication. The plaintiff's pleadings and ours include conflicting authorities on what an officer of the United States may mean. On balance, we think the better interpretation is that it does not include the president. A second point in line with this interpretation is that the president's unique oath does not include the word support, unlike the oaths of the other positions on the list.
No, the president says, I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. The Article 6 oath for senators, representatives, those of us who have the privilege of serving in state judicial office or state legislatures or state executives require that we take an oath to support the Constitution. And I have taken the oath, had the privilege of taking the oath so many times as a commissioned officer in the United States Navy. I do solemnly swear that I will support and defend the Constitution of the United States against all enemies, foreign and domestic, that I take this allegiance with no reservation, and the rest of it. When you take an oath to preserve, protect, and defend, how are you not also taking an oath to support?
It's a fair point. The fact is, though, that the Constitution has two different oaths in it. One specifically is to support the Constitution. The other doesn't.
It doesn't actually, Article 6 does not give the specific language of the oath. And as all of us old enough to recall, and I think everybody in this room is old enough to recall, when President Obama was administered the oath by the Chief Justice, apparently there was some misreading or not an exact one. And the Chief Justice and the President of the United States did it over because it's a constitutional, you must take, it's the only oath that I'm aware of that is specifically ascribed in the Constitution. And 45 citizens of this republic have had the privilege of taking that. No, I'm sorry, 46 have had the opportunity to take that oath. So I don't know. It just, when you say preserve, protect, and defend, and I think back to all the many times I've had the privilege of raising my right hand and putting my hand on the Bible and swearing to support and defend the Constitution of the United States against all enemies, foreign and domestic. I'm not sure. Is it a distinction without a difference?
But yeah, I've taken the oath myself when I was in federal service a couple of times, and all we can say is that Congress chose the words it chose. The president's oath is unique because he's
Congress ratifiers.
The president is a unique position. In our view, he is not an officer like other subordinate officers. He is not a legislator. As we note in our brief, there are legal contexts where officer refers to someone other than the president, such as appointed positions. And the impeachment clause, Congress chose to refer to the president, vice president, and civil officers of the U.S. as if the president and the vice president were not civil officers of the U.S.
And that was a change 6 days before the adoption or the proposal to ratify the Constitution. They withdrew the word other officers.
Yes, Your Honor.
And again, we're required to look at what is in the text, not what is in the legislative history, but sometimes history is informative.
And twice in the last 13 years, the Supreme Court has issued rulings indicating that officers are non-elected positions. I believe we cite Free Enterprise Fund versus public.
Right, the Sarbanes-Oxley or Sarbanes-Oxley case, the Chief Justice Roberts' opinion.
Yes, in which the court observed that the people did not vote for officers of the United States. In Sela Law LLC, the court noted Article 2 distinguishes between two kinds of officers: principal officers, who must be appointed by the president with the advice and consent of the Senate, and inferior officers whose appointment Congress may vest president, courts, or heads of departments. Both of these categories of officers are appointed, not elected. The notion that the prohibition applies to presidents, even though Congress did not name that very special, unique, and position, or that it simply applies to everyone, even though particular positions are named, both seem less plausible than saying Congress was being precise in our view. You have to live.
Well, my understanding is there are 6 elective offices established in the Constitution of the United States. It is the office of president, vice president, representative in Congress, senator in Congress, elector for president, and elector for vice president. Is that your understanding?
Yes, Your Honor.
Right. So they specifically list 4 offices. They do not list 2, but they then say, and all other officers, or I apologize, get the right language here. even with all my binders, I'm not as organized as I would like to be. So I apologize for not having the. No, here we go. Or hold in the description of the offices that are affected, if you will, by the disqualification aspects of section 3. It's the language is, I understand, no person shall be a senator or representative in Congress or elector of president and vice president, or hold, gentlemen, if we could, excuse me. Or under any, or hold any office, civil or military, under the United States or under any state. So any office. Any is all encompassing. How does that not apply to the office of the president?
I think the best treatment of this, in fact, better than ours, you could probably find in the RNC's brief. They're
I read it. I understand.
they run through various provisions of the Constitution, Article 6, the Commissions Clause, the Appointments Clause, and the Impeachments Clause, doing a very fine textual analysis to distinguish between an office and the president,
right.
And provide other authorities where courts have held that the president is not an officer.
All right, I'm going to quote or paraphrase one of my colleagues on the Court of Appeals, and those who have appeared in front of our court, and I know some of the counsel here today have done so on a regular basis, and some of our pro se litigants. One of my colleagues, I think very succinctly will say, tell me why you win. Okay, so my question before, you've got 5 minutes and 10 seconds left. Why do you win?
Number one, Michigan law does not allow the Secretary of State to do what this court have the Secretary of State do. Secretary of State established in their memoranda with the court that they simply do not have the power under Michigan law to disqualify a presidential candidate in an effort to enforce Section 3.
Do you agree that the Secretary's position is as relates to a primary ballot?
It certainly does apply to a primary ballot. I would argue that it also does not, I'm sorry, it also applies equally to the general election.
You agree the Secretary did not articulate that position?
No.
All right.
In addition to Michigan law, federal law, in terms of the political question doctrine, reserves adjudication of disputed presidential disqualification under Section 3 to Congress, in Congress alone. It has the power to create legislation creating a private right of action. It previously had an enforcement act, but there is no such legislation today, which means that power rests exclusively in Congress at this time. Even recently, 2 years ago, considered again creating enforcement legislation, but chose not to do so. Additionally, Section 3 is not a self-executing provision of the Constitution. Furthermore, states.
Why does it have to be in order for this to, the plaintiff to be able to prevail?
I think the baseline starting point is that constitutional provisions are not automatically self-executing, especially when used in an offensive manner, as it is in this case. Additionally, The
Do you agree there are a number of aspects of the 14th Amendment specifically that for 150 years and now going on 170 probably years have been the basis upon which there has been an expansion of claims that citizens can make?
Absolutely. And
How do you distinguish that expansion, which all of us as lawyers of our generation, and Mr. Davis, while not being a member of the bar, is obviously very learned in the law. He spoke very eloquently today. All of us who read the law have seen these cases, read about these cases. Why does that not provide the basis upon which a tribunal, whether it's this one or another, to find such an authority?
for 3 reasons. Number one, in some cases it may be defensive, in which case self-execution is not required. Number two, there is Section 1983, where Congress did enact legislation to allow a private right of action. Number three, Section 3 is different and unique.
Does the, I'm glad you talked about Section 1983. And we're talking about 42 USC 1983, is that correct?
Yes, sir.
Okay. Does 42 USC Section 1983 and its adoption and utilization by litigants for a substantial period of time since its adoption, does that then make it such that we now know that when Congress wishes the 14th Amendment to provide a cause of action, that there must first be a statutory enactment by Congress? Do you think it stands for that proposition?
Yes, we do, Your Honor. And
Do you
additionally,
have a case that stands for that proposition?
not at the tip of my fingers, Your Honor, I apologize. But we also have, specifically with reference to Section 3, Congress's history of enacting enforcement and then repealing it, and then considering it again just 2 years ago. So Congress certainly knows how to pass legislation to enforce Section 3 and distribute its power however it so chooses. This time, it has chosen not to
Okay.
give that power to anyone.
All right, you're out of time, but you can sum up if you want. I do know, I suspect I'll see somebody from your table a few more times today, so you can sit or you can just give us a brief summary or whatever.
Thank you, Your Honor.
All right. Thank you for your thoughtful observations and comments. All right. Counsel for the Secretary.
Thank you, Your Honor.
Thank you.
I hate to bring us back to the date of the primary again.
No, actually, I'm so glad you have, because I was hoping you would want to go back to that, because I thought Mr. Davis's his argument was very thought-provoking for me. So I'd be happy to hear what your thoughts are now.
I think I found it less persuasive than perhaps
I
Your
didn't say
Honor.
I found it persuasive. I didn't say I found anybody's position persuasive at this juncture. I did find it thought-provoking, though.
No, and I do understand the point that Mr. Davis is trying to make. I reject it because the only thing that Public Act 2 did was amend 1613, the date of the primary, right? That is the only thing Public Act 2
Okay.
did.
Yes.
So no other statutes are hooked to that, right? It's just that's the date of the primary that changed.
That's my understanding.
That is going to become effective, let's say legislature adjourns tomorrow, next week,
Let's say it's
right?
January 1st, whatever date.
Yeah, it's going to become effective and change the date of our primary to February 27th,
Yeah.
right? None of the other statutes, everything else goes backwards from, I think what Mr. Davis is essentially trying to say is that everybody, the counties and all the other dates are somehow locked in to dates that cannot be made to work with the new primary date. But somehow, you know,
Right.
if you understand what I'm saying.
But he particularly relied on, I thought, the in-ray request for advisory opinion, 479 Michigan 1 at page 12. You know what?
That's the photo ID case, right?
I
think
I
I
don't
should
know.
because I was in that case, if that's what it is.
Oh,
but
you were there.
I didn't have time to look at it, but I don't think it, I think we don't, everything flows. If you change the primary date to February 27th, that Public Act 2 does.
Right,
Everything flows backwards from that date.
right. But
is
Mr. Davis's
enforceable.
position is, Judge, the secretary is making all of these, if you adopt their position, by doing that, you're letting the secretary force all these local election boards to generate their absentee ballots and engage in the absentee ballot process based on what the law is gonna be, not on what the law is.
I think that's true because
Why not?
the dates for everybody to do things
Mhm.
are not dates certain, right? They all just flow back a number of days from whatever the primary date is. So whatever the
Right.
primary date is controls the date that ballots need to be printed by and all the other operations. So there isn't, so it's
I've had the privilege of being on the ballot a bunch of times. I'm so grateful that I've had the opportunity to be elected. I've won, I've lost elections. Well, I've lost one election anyway, but at any rate, I've been on the ballot. My point is, when you're a candidate, you get you get a proof ballot. It gets mailed to either your committee or to your home. And those of us who have, well, at any rate, I'd get these proof ballots. And every time I've been on the ballot, and I don't know, I guess it's 10 or 12 times from precinct delegate to circuit court to candidates and primaries and all this good stuff. But that, if I'm understanding it, if there's a proof ballot, well, A, is there a proof ballot for the presidential primary? Do you know? Mr. Davis is nodding that there is, so I know he's not
I
testifying.
would think so.
But I would think
might-
there would-
I hadn't thought about.
So
the proof ballots.
if there is a proof ballot, you're sending a proof ballot out that says, Jim Redford, James Robert Redford, your candidate for precinct delegate in, whatever district. James Robert Redford, your candidate for the primary for the 17th Circuit Court in 2002. And there were a whole bunch of other names on that. And so, but that was months before the ballot was actually printed, or at least 45 days before it was printed. And when I've been on the general election ballot, you start getting them about the 16th of September. Not that rings a bell, but, and then each of the 17 counties I've stood in an election for the last 2 times, you get them a little bit earlier or a little bit later. But my point is, if that's the case, why isn't there some currency to what Mr. Davis is suggesting?
If I understand, what he's arguing is, despite the fact that the law will require us to hold our primary on February 27th, we can't do anything to effectuate that. That's what he's
Okay.
saying, right? And I reject that. Because if that's the date, we have to hold it, because the law will say that we have to hold it on that date. Right.
If they recess,
If
as
it resets,
as
yep, if
everybody
they
sort of
recess in time,
anticipates.
all of that, right?
Okay,
The argument is that somehow we can't take action to effectuate the law. So I don't think that's correct.
all right.
And again, all of these statutes operate the remaining statutes sort of just operate independently of the primary date statute, right? So none of those are hooked to, the passage, the effective date necessarily of,
Okay.
you go by the number of days, the Constitution requires 45 days for military ballots, overseas and military ballots. The Constitution compels that, right?
Right.
So we would have to take action to do that. So, and half this process.
Haven't been a recipient of those ballots a
You
few
get those
times.
too,
I
right? That's
appreciate
right.
that.
So I
It's
mean,
important
everything
that
is
we give our sailors, Marines,
statutes that
airmen.
are working right now. So the date of the list,
Yep,
right?
okay.
The lists
All
and
right,
all that
I understand
are
the position.
controlled by statutes that are only impacted by Public Act 2 because it will sort of just change the date by which we operate.
All right.
by.
Well, I'll certainly review the case Mr. Davis has cited for us. And yeah, I'll look for that. Good. What else would you like to share with the court?
Just turning back to, well, I guess the new thing he did bring up, wasn't going to go there, but on count 6, which is the other count that we did move to dismiss on, that is the claim
Right.
that we did not promulgate rules for the electronic return of military ballots. We
Yes.
did
And you
start,
got about a
yeah,
minute and a half left.
okay. We did start that, Senate Bill 70 has been signed by the governor. There is now a public act that will obviously always will be effective, just like Public Act 2, after the adjournment of the legislature in 90 days. That changed electronic return for military ballots. We don't have to start doing that until September of 2025.
So does it make it moot? Does it make it not ripe? What's the,
I think it makes it moot, but worst case scenario, Your Honor, if somehow we were out of compliance with the law as it stands today, even if that was
Okay.
true, the court has discretion to grant declaratory relief or not, even if there's an actual controversy and all that. And under the circumstances when the law is changing to only require us to do that in September of 2025, I don't see how relief is warranted,
all right,
in this scenario.
thank you.
All right.
Anything else?
Questions, I can sit down so we can take a break.
I don't. I like that idea as well. Okay. All right. Mr. Davis, thank you so much for your advocacy on behalf of the position you're articulating. Is there anything very briefly you'd like to share before we recess?
Yes, sir.
Quickly.
60 seconds.
No more.
Just on the date of the election issue.
Okay.
Operational. The law cannot go into effect or cannot operate. Secretary of State cannot effectuate or implement said law until the date it goes into effect.
Okay. Thank you. I appreciate your position. I appreciate your very thoughtful and well-prepared submissions and briefs and your interest in advocacy in these areas. Thank you. Mr. Colombo, you good? All right. It's now 10 minutes after 10. Mr. Brewer, you're next as the moving party. We're scheduled to start at 11:30. Well, first, let me ask our court reporter, Ms. Roberts, do you want to break till 11:30 or till 11 or till? That's, you are clairvoyant, Mrs. Roberts, not unexpectedly. Yeah, that would be sort of my thoughts, depending upon what the. I don't want to start at 10:30. I need till at least 10:45. So, but if we were, I don't know what that schedule does for the other litigants. Mr. Davis, you're done. So I appreciate your being here. Mr. Brewer, you're okay. And on behalf of the secretary, would you be ready to go at say 10:45? Okay, 10:45 work?
Mr. Brewer, you want to make work, Mr. Davis?
And
And I would like to confirm.
all right, is there anything else we should take up before we recess in the matter of 23-00128-MB? Mr. Davis. Right. If you, yeah, yes. So whatever opinion and order that gets issued, it'll indicate it's not a final order because we have pending counts so in 128. Thank you. My guess, anything else? Mr. Colombo? All right, court is in recess. Please feel free to go about your business. We'll reconvene in case 23-0015, I'm sorry, 137 at 10:45. Thank you. Please, I'm going to be working here, so please go ahead and do whatever else you need to do. I don't want to
Yeah, it's very interesting.
But you have probably related.
Yeah.
Thank you. Be seated. Sure, let me know when you're ready. Okay. Ready? Okay. All right, great. Good morning. The court calls the matter of Robert LeBrant, Andrew Braidway, Noah Murphy, and William Noling versus as plaintiffs versus Jocelyn Benson in her official capacity as Secretary of State of the state of Michigan. This is the Court of Claims case number 23-000137 MZ. My name is James Robert Redford. I have the privilege of presiding over this matter. The case was set to be called, I think, at 11:30. And thank you for the cooperation and willingness of our lawyers and parties to proceed a little earlier. The earlier matter, case 23-128, was completed earlier than had been on the schedule provided for. The attorneys in the case for the plaintiff are Mark Brewer and Rowan Conybeare for plaintiffs. For defendant Benson, Heather Meingast, Eric Grill. Ms. Meingast appears in court. Pro Hoc Vice attorneys are, I believe, Mr. Colombo and Mr. Meiser. Is that correct? All right. There are a number of other attorneys on who have submitted matters to the court. During the recess between the first hearing and this one, I did receive an email from one of our court staff, and there was a request when lawyers are speaking, if you could approach the podium, because this is being live streamed, and there is not insubstantial interest in the matters which we have the privilege of serving as a judicial officer or as counsel of record on. So I know it will slow the proceedings down a little bit, but since we're not in the midst of a heated evidentiary hearing where there'll be objections right and left, if we could just, if you do, if you're going to interpose anything, if you let me know, I'll determine whether I'm not going to interrupt other counsel, and we'll proceed that way. I'm going to look for nods of the head. Does that sound satisfactory? Okay, plaintiffs look good, defendants look good, amici look okay. All right, great. All right, so today's the day that the court has scheduled for hearings in this. I first want to, as I did in the previous matter, thank and acknowledge the excellent submissions by the plaintiff, by the defendants, by the amicus who are present here today, as well as other amicus filers. The submissions were uniformly well presented, thoughtful, argued with great persuasive ability, and I appreciate it very much. It's a privilege to preside over these hearings. It's a privilege to serve as a judge on the Michigan Court of Claims pursuant to order of the Michigan Supreme Court, as opposed to the office I normally have the privilege of serving in that I was elected to as a judge of the Court of Appeals. So thank you to everyone here and to all the amicus filers who submitted pleadings, and thank you for your request to present oral argument. The amicus, other than Donald J. Trump's, no other amicus filers are being allowed to present oral argument. I felt that there was an adequate representation of the pleadings that have been submitted. So, but before we get started for oral argument on the motions first brought by the Secretary of Defense, I want to give Mr. Brewer and Ms. Conybeare an opportunity. Is there anything you would like to say or that we should address before we proceed? And if whoever's going to talk, if you could just come to the podium, so count the folks who are watching will have the benefit of whatever your comments might be. So good morning.
Good morning, Your Honor.
Nice to see you.
Mark Brewer, together with Rowan Conybeare, as well as our colleagues at Free Speech for People. I want to make sure they are acknowledged as on behalf of the plaintiffs. We have no administrative matters to bring before the court. We are eager to get to oral argument.
As am I to hear your oral argument. Thank you. On behalf of the people, Ms. Meingast.
Thank you, Your Honor. Just to clarify, on behalf of the Secretary, I don't have any housekeeping matters. As I understand it, Mark will be, Mr. Brewer will be presenting sort of an affirmative argument first. Is that how we?
Oh, how do we want to do it? What did I say? Yeah, please. And Mr. Colombo, or let's have all three of you up here so we can all agree on how we're going to do the batting order. Sorry.
The scheduling order indicated that plaintiffs would go first.
Okay, I'm sorry.
Matter, which is fine with us.
Okay.
That works for me. Just to clarify, we don't have a motion pending. The Secretary does not have a motion pending in this one, so it is a little bit.
I think that's. There's no problem from the amicus. All right, excellent. Thank you. Mr. Colombo, while everybody's up, do you have anything to add before we get started? All right. Then on behalf of plaintiffs, whoever is going to be presenting oral argument, and if you can, since you're going first, Let me know if you want to reserve any time for follow-on comments after sister and brother council are completed. And if so, if you want to tell me how much, I'll be happy to try to adjust my running clock to that. And I apologize if people are keeping track of exactly how much time. I never seem to get it exactly right. So anyway, Mr. Brewer, it's nice to see you, sir. And would you like to have any time on rebuttal?
Good to see you, Your Honor. Yes, I'd like to reserve 5 minutes
Perfect.
of my
Okay.
30 minutes, please.
All right. Whenever you're ready to go.
Thank you, Your Honor. May it please the court, Mark Brewer and Rowan Connie Bear, the law firm of Goodman Acker, plus our colleagues at Free Speech for People on behalf of the plaintiffs in this matter. I am going to discard my prepared remarks, having been here in the prior matter and seeing the issues the court was interested in discussing, had questions about. Of course, I'm open to any other questions the court may have, but I thought we should get right to it in terms of the issues that have been raised. I'd first like to address the Minnesota decision of yesterday. Minnesota's state law regarding election and particularly candidate eligibility is vastly different from Michigan's. Plaintiffs, like all Michigan voters, have a right to only have eligible candidates on the primary election ballot. And among the many authorities for that, which we cited this in our complaint, Your Honor, is the decision in Barrow versus City of Detroit Election Commission involved access to the primary election ballot, particularly appropriate here. And in that case, unanimous decision written by your colleague, Judge Murray, the court said that if the candidate, quote, did not meet the qualifications for elected office under the charter, plaintiff would have the clear legal right to have that candidate's name removed from the list of candidates. This and other authorities establish, again, that Michigan is vastly different than Minnesota. Not only do candidates have no constitutional right to appear, and I'll deal with the political parties in a moment, but voters have a right to have only eligible candidates on the ballot. And that is the square question presented to the Secretary of State and to the court.
And as you proceed through your remarks, and thank you for your initial comments already, they're very helpful. If you can also address, and I'm sure you will, or suspect you will anyway, the issue about, is the presidential primary election a different situation?
So the carve-out that Your Honor adverted to in the prior matter. So yes, I will address that.
So thank you.
So again, we start with the premise that Michigan law is vastly different from Minnesota. Here, voters have a right to exclude ineligible candidates from the ballot. Vastly different from the situation in Minnesota.
So do you think any registered voter in Michigan can bring a cause of action seeking either mandamus or injunctive relief from the secretary, and I guess it would be in the Court of Claims now, to exclude someone? If they say, Bill Smith is not qualified to be governor because they're not a resident. Jane Jones is not qualified to be a senator because they're not a U.S. citizen. It's your position that Michigan law provides standing to every single voter in that district that's affected can bring a cause of action.
Yes, Your Honor. As we discussed the standing as you in our brief, Michigan has very broad voter standing. It's not like Article 3, which frankly distinguishes many of the cases cited by the lawyers for Mr. Trump. A lot of them are based on Article 3 standing. Those federal cases completely inapplicable because Michigan has, and has had for a long time, much broader voter standing because Michigan recognizes the interest of every voter in the relevant district, in the integrity of the election, and making sure there are only eligible candidates on the ballot. So set aside those Article 3 cases in terms of dismissing people without standing in federal court. They are not applicable here. Michigan has much broader standing. But let me turn to the other questions that the court had with that premise that Michigan law provides that candidates have no right to the ballot. Bear with me here as I turn the page on my notes. So as Your Honor just hinted at, Michigan candidates are often removed from the primary ballot based on non-residency. This is a fact-intensive proceeding, which is exactly what Your Honor would have to engage in here.
Right. And when that proceeding takes place, is it with the State Board of Canvassers? Is it through the judicial process? Is it through the Secretary's office? What is your position?
All three, Your Honor, depending on the office. Depending on the office. There have been cases involving residency in the Court of Claims. Had to be resolved by some of your prior colleague, Judge Stevens, in this case, I recall.
Judge Stevens had so many cases
Right.
in the 4 years I served.
But she had a
before.
residency case that arose that she had to adjudicate. Sometimes those issues are brought to the Board of Canvassers when it has jurisdiction. There are times when the Secretary of State has jurisdiction, and I want to discuss a couple of those with you now, if I may, to demonstrate that here the Secretary of State has the obligation and the ability, and has done those kinds of eligibility determinations in the past. In 2022, Your Honor, I represented former Judge Carl Marlinga, who resigned from the bench to run for Congress. But he did so in alleged violation of Article 6, Section 21, which says you have to be away from the bench, gone from the bench for a year before you can be a candidate for office. A challenge was brought to his candidacy. It was filed to the Secretary of State, and a decision was made by the Director of Elections. So that's an example of, in that case, actually a federal candidate. It involved questions of state constitutional law, but also the federal constitution, because one of the issues there.
What do you think, what was the federal constitutional for Judge Marlinga's judge, prosecutor, law partner, Bushnell Gage?
And I'd be pleased to send the papers, Your Honor, if you're interested. I can summarize.
Just summarize.
The question was whether Article 6, Section 21 of the Michigan Constitution added to the constitutional requirements to serve and to run for Congress in Article 1, Section 2. So you had the Secretary of State analyzing and making decisions on an administrative basis about the eligibility of a federal candidate for office. So again, this is not uncommon. There's several different bases for this. Mr. Davis in the previous matter cited MCL 168.31H. That's a basis in terms of the Secretary of State's authority to investigate. But if nothing else, Your Honor, and I was surprised not to hear this mentioned this morning, the Supremacy Clause binds the Secretary of State. She cannot ignore the 14th Amendment and specifically Section 3 under the Supremacy Clause. That is the law of the United States. She can't simply say, well, I'm sorry, I can't enforce the U.S. Constitution. No, the Supremacy Clause says that section of the Constitution binds her and she must address it. We can get to issues of self-execution and so forth in a moment, Your Honor.
When you and Ms. Countybear are presenting your statements to me, if you had a minute to address that fairly recent New Hampshire federal court decision that sort of addressed a lot of these issues, I'd be curious.
One of the Castro case, which I believe
It's one of the Castro cases.
Right.
I don't need it right now, but just as you were talking about the Supremacy Clause, it made me think about that particular piece of jurisprudence. So at any rate.
And I will turn to the political question doctrine shortly.
Right, yeah, I'm not trying to throw you too many.
No, that's fine. That's fine,
So,
Your Honor.
yeah.
So, I mean, we have all these premises. The Secretary of State has the authority. She has done so. But as you indicated, Your Honor, in one forum or another, as you asked this morning in the prior matter, if not Secretary of State, who? Your Honor, in this case, it's you. If not the Secretary of State then when? The answer is now, in this court.
Mm-hmm.
So at this point, in terms of our matter, the question of the Secretary's authority is moot. We're here. We're asking this court for declaratory and injunctive relief to do what we believe the Secretary could have and should have done, but we're past that point, particularly in terms of the chronology that Your Honor is very aware of. Now, states routinely adjudicate presidential candidates' qualifications before elections. We cited in our brief the Hassan versus Colorado case out of the 10th Circuit. We also cited Lindsay versus Bowen from the 9th Circuit at 214, which, by the way, Your Honor, the Lindsay versus Bowen case supersedes the cases that we heard counsel in the earlier matter cite from Mr. Trump. Those cases, the Grenoir decision, which was an unpublished decision, has been superseded, and frankly, the decision there was dictum and involved a post-election suit to annul an election. Completely inapplicable here, but in any event, superseded by Lindsay. Same thing with Robinson versus Bowen. Lindsay is the current law of the Sixth Circuit, and Lindsay supports.
What's the site? And I know it's in the materials, but if you happen to have it.
The Lindsay case, Your Honor, is at 750 F 3rd 1061, a Ninth Circuit case out of 2014. And a particular relevance here, that upheld the state's exclusion of an underage candidate from the ballot. I know there was a subject of some colloquy this morning that if an underage candidate presented him or herself here in Michigan, or even if Barack Obama, who I would love to vote for again, but if he presented himself to be a candidate here in Michigan, the Secretary of State could and should say, no, you cannot appear on the ballot. You cannot petition. You cannot appear on a party list. You cannot appear on the ballot because you are constitutionally unqualified, just as we believe Mr. Trump is here.
In the Lindsay case, Mr. Brewer, what office was the candidate seeking, and was it a primary or general election?
I believe that person wanted to be on the presidential ballot.
Oh.
So we can check that for Your Honor.
I'll be able to find out. Just
Anyway, the principle is that the states have the authority to exclude unqualified candidates.
is that a Michigan case?
The Lindsay case arose out of California, I believe, Your Honor.
Okay.
I do not have a copy of the case in front of me,
Nope,
so I
thank
want to
you.
be candid with
No,
the court.
thank you. If you had every case that's cited in all of these pleadings, I think you would have had to bring a U-Haul with you.
So again, we cite in our brief, we quote from now Justice Gorsuch's opinion in the Hassan case that a state has a legitimate interest in protecting the integrity and practical functioning of its political process. And it is allowed to exclude from the ballot presidential candidates who are constitutionally prohibited from assuming office. The court couldn't have been any clearer than it was in the Hassan case. And there's also, of course, the Green versus Raffensperger case, which we also cite, which ultimately a candidate was not disqualified under Section 3, but the court did not question and reaffirmed the authority of the state to so do so. But I also want to address this question of, well, the political parties, don't they have a right to do this? They do not, Your Honor.
Why not?
In the case of Timmons versus Twin Cities Area New Party, a 1997 United States Supreme Court case, 520 U.S. 351 at 359, the court said as follows: it does not follow, though, that a party is absolutely entitled to have its nominee appear on the ballot as that party's candidate. A particular candidate might be ineligible for office. So the United States Supreme Court itself has recognized that, in this case, the Republican Party can't dragoon the Michigan election process and insist that ineligible candidates, for whatever reason, maybe it's Section 3, maybe it's age, whatever, appear on the primary ballot. And that doesn't leave the political party without alternatives. And I know this, Your Honor, and you know this as a former Michigan Democratic Party chair. In this state—
Yeah, you've been involved in a couple of these elections, I think.
Yes, Your Honor. In this state, parties frequently do not use the primary process for a variety of reasons. Maybe the date doesn't fit the national calendar, or there may be other problems. And both political parties have another option. They can hold an internal process. Their First Amendment freedom of association rights are respected, but they have no right to dragoon, to commandeer the state election process and put ineligible candidates on the ballot. And that's the issue here. The First Amendment rights do not do that.
If a party wanted to have a caucus process instead of a primary process, would that be governed by the MCLs?
No, Your Honor. The case law on that, going back to the 80s, Cousins versus Wagoda and so forth, indicate that states cannot regulate the internal procedures of the party. At that point, Michigan and many other states attempted to regulate who could be delegates. And in Cousins and a number of other cases, the Supreme Court said, no, you may not. That's up to the parties to decide who their delegates are and how they are to be selected.
But there, in some of the sections of the Michigan election code that are in proximity to, but not in the specific presidential electoral one, they do speak to county conventions, and I'm sure you've been a precinct and a county delegate, and I have too back in the day, long before I was a judge, not long, but before I was a judge. And you go there, you stand for precinct delegate, you get elected or you don't. If you get elected, then you go to the county convention. But the statutes, they really set forth a lot of the business practices, if you will. It looked like to me, anyway, and as a former party chair, I mean, I wonder what your thoughts are on that.
Those provisions generally date to the 1950s, long before Cousins, long before Tasjian, long before a whole series of United States Supreme Court decisions, which said that the state cannot regulate the internal processes of parties. So frankly, Your Honor, many of those statutes are frankly dead letters. They're particularly dead when it comes to the presidential primary because there's a specific case on that. Now, what happens in this state in both parties is that the parties can voluntarily follow state law and hold county conventions and use those eligibility requirements. I can speak for my own party, the Democratic Party. They by and large do not. But again, that can vary from cycle to cycle. Those state laws, if they were ever attempted to be enforced, I'm confident would be struck down as unconstitutional based on Cousins, Tasjian, and a whole series of cases.
But if a party did want to have a caucus, as has happened in my lifetime in Michigan a few times, not often, but a couple of times, your position is that at that point, that's a private association situation. You know, so long as they're not doing anything criminally unlawful, you get to do pretty much what you want.
And the only narrow exception to that would be the white primary cases, you know, out of Texas in the 1930s, where essentially the state delegated its entire authority to run elections to the Texas Democratic Party, which was a racist organization at that time. The United States Supreme Court said that goes too far. And they said that's state action. Short of that, these are all private matters for the party to resolve internally. And again, they don't have a right to commandeer the state primary process, particularly with an ineligible candidate.
I understand
Yes.
your position on, I think I understand your position on eligibility, but your position, if correct, doesn't it make a dead letter the last sentence of Section 3 of the 14th Amendment about the ability of the 2/3 vote of both houses to remove the disability?
I don't believe so, Your Honor. If that disability was ever removed prior to somebody wanting to appear on the ballot, that could be honored.
It
should be
could,
honored.
and you briefed that. I recall that in your brief. I thought that was interesting position on it. But when I look through this is, okay, let's assume that either I or some other tribunal says this section applies to candidates for president. The oath that Mr. Trump took satisfies the oath requirement, and we're satisfied factually that there was the other conditions preceding to disqualification. There was an insurrection that he either participated. So let's assume somebody does that. If that were to happen, and all of those things could happen, but the 2/3, but the amendment, Section 3 still provides, if you can have those disabilities removed by a 2/3 vote of the House and the Senate. And that happened in the 1870s with the Amnesty Act. It happened writ large, and it happened with individual bills of relief before the Amnesty Act. And what I'm having, if that, it's still the law. I don't think you disagree with that, right? The relief.
Relief is there. Matter of fact, that is the only role for Congress in this entire process. We'll get to that in a moment in terms of the political question doctrine.
But your position is you got to do it beforehand.
Before your eligibility would be determined. Now, perhaps.
Do you know of any case since the adoption of the amendment that a person seeking to become a candidate for office, as opposed to someone who had already stood and was seeking to serve, has sought that 2/3 relief?
I'm not aware of any, and that's obviously a political legislative approach as opposed to a legal one. I'm not aware of any, Your Honor, but I think here's the way it would play out. We are now determining the eligibility for the presidential primary, and the clock is ticking. We believe Trump is disqualified under Section 3. That doesn't mean, even if he doesn't appear on the Michigan ballot in February, that he could not have the disqualification lifted and appear on the general election ballot. But it's entirely speculative at this point in terms of whether that disqualification will ever be lifted by a 2/3 majority of the Congress. He hasn't even asked for that amnesty.
Right.
John, if I may, I'd like to turn to the political
Please.
question doctrine, which you had a number of questions
I'd be
about.
very interested to hear your
That-
position. And you're at about 19, you're about 20 minutes right now, so you got about
Thank you,
5
Your Honor.
before we get to rebuttal.
I think, Your Honor, on the political question doctrine, we need to go back to the source, which is Baker versus Carr. There's been a lot of argument in the briefs and here this morning. The two critical standards for a non-justiciable political question stated in Baker versus Carr, and this is at page 686 of that decision, is one, whether there is a textually demonstrable constitutional commitment of an issue to a coordinate political department, or two, is there a lack of judicially discoverable and manageable standards for resolving the dispute? Those are the two tests.
Mhm.
And Trump meets neither of those here.
What's the second one again?
Baker versus Carr
No, yep.
is, Your Honor,
Yeah, I just-
369 US 186.
No, I know, I'm sorry. What's the second? You said there's two tests, and
Yes.
I was taking my notes, and I know they're in my files, but what's your position on the second
Whether
test?
there is a lack of judicially discoverable and manageable standards for resolving it. So I'd like to deal with these in order, if I may.
Please.
First, there is no text which commits the qualifications to be President of the United States to the Congress. Trump relies on the 12th Amendment and the 20th Amendment. All the 12th Amendment does, it's important, but not in this context, it instructs Congress to count votes. It doesn't say anything about judging the qualifications of those candidates. An exercise we went through on January 6th and got the vice president involved, unfortunately, which I'll talk about later if I have time. They also cite the 20th Amendment. All that does is provide a contingency plan if the president-elect shall have failed to qualify. It does not allow or commit to Congress the authority to determine those qualifications. There's nothing that can be pointed to in the text of the Constitution that allows the Congress to determine those qualifications, other than in the case where we have seen this before in the specific text in Section 3. And we are textualists. The only thing that Section 3 allows is amnesty to lift the disqualification. That is the only role for Congress. And by
But
saying,
what about the 20th Amendment, Section 3, that speaks to when or if the president-elect fails to qualify for office?
yes, but that doesn't empower the Congress to make that determination.
No, but the Succession of the Presidency Act does, or not act, amendment in the 25th.
Right?
So as I understand your position is that there's the first part of Baker that's most relevant is that there's no textual demonstration that there's a constitutional commitment to allow the other branches to do this.
Correct.
Okay,
Specifically the Congress.
right. And so the ones that I'm looking at, I look at 12, the 12th Amendment, the final sentence of Section 3, it's the 14th Amendment. The presidential election fails to qualify language in Section 3 of the 20th Amendment. In the Succession of the Presidency Amendment of the 25th. It seems like those talk an awful lot about Congress's role when a president or a president-elect fails to qualify for service.
All of those important amendments deal with process. What happens if this contingency occurs? What happens if this contingency occurs? And they give a role to Congress in some of those instances. But none of those constitutional amendments give Congress the power in the first instance to determine whether a president is qualified or disqualified. They are contingencies. They are process oriented to deal with various historical problems we've had. in this country, but nothing in there authorizes the Congress to second guess the qualifications of a presidential candidate. That is left under our system in the first instance to the states. Other provisions of the Constitution say the states determine who gets elected as an elector, right? Who gets to be determined to be a candidate. That's all delegated to the states. And that's one other reason why we are here, because this part of the electoral process is within the control of the states under the federal Constitution.
Okay. If it is under the power of the states, under the federal Constitution, and I agree with you that it is, then why doesn't what we talked about right at the beginning, MCL 614 sub A, sub 615A, 615B, C, why doesn't that end our dialogue? If the states are responsible for the electors, and it's such an interesting historical thing, we as a nation, it's the only thing we do together is we elect a president and vice president, but we actually elect electors to the presidency or the vice presidency.
Right. Your Honor, those provisions have to be read in conjunction with the Barrow case and the other authorities that say, in addition to the Secretary of State naming it and the process laid out, voters have a role in this. The voters I represent here this morning, they can step up and say, that person is not qualified. They should not be listed on the Secretary's list about to be promulgated or put in by the parties. So those types of provisions say what they say, but they have to be read in conjunction with the Michigan case law, which gives voters the right to question those candidates' eligibility and through a judicial process, knock them off the ballot. That's how we're different from Minnesota, Your Honor. There's no such provision in Minnesota that gives voters standing to question the eligibility of candidates.
Well,
On a second, if I may, Your Honor, unless you have questions,
Please.
I just want to proceed in terms of
Yeah,
the Baker
I
versus
don't-
Carr analysis. There are judicial standards. Courts do this all the time, Your Honor. What we're asking you to do,
we're at about 27 almost, so.
okay, what we're asking you to do is what courts do all the time. They make factual determinations based on a hearing, and we believe a brief hearing is necessary here for you to hear the
No,
facts.
I think if it's, yeah, if it's
And then you-
factual, I think we got, it's,
Right, and then you apply the constitutional standards. So that portion of Baker fails as well. The political question doctrine does not apply here. Now, does this case involve politics? Yes, but it does not involve the application of the political question doctrine so as to immunize Mr. Trump and say he should be put on the ballot.
very, all right. Want to save the rest of your
At
time?
this point, yeah, you're right. I think I
Okay.
would reserve the rest of my time.
Mr. Brewer, I know you asked for a little change in the oral argument schedule, and I would have loved to give every party 2 hours. I think you have all so well prepared for this. Mr. Davis did earlier, the council did earlier, and I have no doubt they will in this and the subsequent case. It's just, we all together have to get this from my desk to somebody else's, and so I wish we had more time. Judge Joe Scoville used to say when I was a federal prosecutor, he quoted a partner he used to work for, "Your Honor, if I'd had more time, I'd have been shorter." And I sort of.
Your Honor, thank you very much. We're simply trying to help.
No, I'm so grateful for
I remain at
everything
the
you
court's
said.
disposal, and I'll reserve the balance of my time.
Thank you. We'll reserve 5 minutes for you since I took up some of your time unfairly. All right.
Your Honor, Heather Mangus on behalf of Secretary Benson. Your Honor, I'm not going to reiterate all of the arguments that I made in the context of the Davis case. I think the court's familiar with our position.
Right. Let me just interrupt you there.
Sure, go ahead.
Is there any position to the court sort of adopting and considering Ms. Meinstadt's arguments from the case 23-128 on behalf of the plaintiffs? Yeah, no worries. And counsel for the Secretary of State has just said she'd like to, she's acknowledged, and all of us have been literally in this same room together this morning, together with our outstanding court reporter. And she asked if you said, I've considered, or you've heard my previous position. I'm not going to repeat it. And I wondered on behalf of the plaintiffs, is there any objection to the court incorporating those by reference for this matter?
Your Honor, I did that in my argument. So yes.
I know, but I want to make sure we have I'm trying to remember the rules of being a trial judge, make sure I make a good record. So, okay. Thank you, Mr. Brewer.
Thank you.
Sorry. Colombo. I don't know. It's only been here, Your Honor. Okay.
Hoping you would say that.
Thank you. Excellent. Okay. So the court will consider that and proceed.
Thank you. So with that being said, I just want to clarify, again, our position is that it is not the secretary's job or within her authority to make the decision as to whether Mr. Trump is disqualified. So we're not advocating today necessarily that he should be on the ballot or off the ballot, right? Our position is it's just simply not our task. I did listen to Mr. Brewer.
Yeah, what do you think? Mr. Brewer raised a lot of interesting points, I thought. Among others were in the situation with former prosecutor, former Judge Marlinga, that there was some type of administrative, something happened with the director of elections and made certain findings involving both Michigan and U.S. constitutional qualifications.
Your Honor, it's only been a year. We said it was 2022, but it seems like a lifetime. I'm simply not recalling the specific situation.
I know that feeling. Wait till you have grandchildren, and then you really feel it.
Not there yet.
Yeah. I highly recommend it.
But the question is, what is our authority here today with respect to a presidential primary candidate?
Mm-hmm.
And I think for all the same reasons I've already argued, there's just nothing in those statutes or, even a generic sort of administrative process or anything that gives us the authority. And I think Mr. Brewer is sort of overstating the robustness of our statutes allowing candidate challenges. They really aren't that robust, and there simply isn't a process here with respect to presidential primary candidates.
What about Mr. Brewer's arguments about the secretary's responsibilities, constitutional responsibilities to under the supremacy clause? We all understand as lawyers after I don't know about where you went to law school, but where I went, Con Law 1 was usually a first semester, second year. And Professor William Downs taught it well at the University of Detroit where I went. At any rate, the supremacy clause, obviously part of the U.S. Constitution, supreme law of the land. Mr. Brewer says, hey, Judge, the secretary under the supremacy clause, which incorporates all of the Constitution and its amendments, requires the secretary to do this. And if she won't do it, you need to do it. So what's your position of the secretary has a responsibility to do it under the supremacy clause?
Well, I think this similar to Mr. Davis's argument. His argument was that when the secretary took an oath to uphold, our state and federal constitutions, his argument was that she had a duty to just apply this analysis and engage in this 14th Amendment analysis. But I mean, pledging to support the Constitution or follow it is not the same, and we will do that, right? That's not the same as having the ability to enforce it. I still do not have we do not have a vehicle in which to engage in this analysis as to whether the former president should be disqualified.
Does many of the State Departments have administrative law judges who are assigned to them? Does the Department of Secretary of State have administrative law judges for, I'm sure you do for driver's license and things like that. But does the Department of Secretary of State have ALJs assigned to it for purposes of election matters?
No.
All right. There is a state board of canvassers. The members of the board of canvassers, my recollection is there are 4 members, two from each of the primary parties appointed by the governor to vacancies if a member from one party resigns, retires, is removed, or passes away, then the incumbent governor appoints a new member of the same party with the advice and consent of the Senate. Is that right?
I think that's right. I think there's
All right.
nominations from the parties. The parties.
Yeah. I
right.
think my recollection is there's, 2 to 3 names provided by whatever.
Right.
The State Board of Canvassers entertains challenges to petitions, challenges to canvassing, challenges to candidates fairly routinely. Why wouldn't that be a vessel through which this ship could navigate?
Because this doesn't go to the Board of Canvassers. Right, nothing about, the only role that the Board of Canvassers has with respect to the primary is to certify the result. And under our new constitutional amendment, all you can do is certify the result based on the reports from the counties. There's no additional investigation or query behind that. It's
Okay.
simply a certified
So your
result.
position is the State Board of Canvassers is not a viable mechanism to undertake the adjudication process.
Not for a presidential primary candidate, because nothing about that candidacy goes before the board.
Okay.
Right, and the only thing the board really addresses with respect to candidates is challenges, and the law provides for this basically, to challenge a candidate's petition, their nominating petition. Do they have sufficient ballot signatures? So those are the kinds of challenges, and also challenge to basically the front of the petition, did they properly name the office and their residential address and all that. That's, so the board does not address eligibility or qualifications issues. That they might be pressed to do that, but that's not really within their statutes either.
Okay, thank you.
And I would just note that while I listened to Mr. Brewer say that it's our job to do this, just looking at the count, that's his claims and his complaint, that's not what he's asking, right? His count 1 is for declaratory relief, but it clearly seems to be saying to have you declare Mr. Trump ineligible, not declare that the secretary has a job to do it and send it back to us. So when I read the allegations in his complaint about it being our role, to me, they were more of present there to sort of support an actual controversy being present between the parties in this case. But when I look at the relief requested, he's not asking you to declare that it's the secretary's job. He's asking you to declare that Mr. Trump is disqualified under the 14th Amendment. So it seems like in the context of this case, the arguments about whether it's our job or not, that's not what the ultimate relief is here.
Okay. Anything else?
Unless you have kind of-
All right, thank you. Hold on just a minute, Ms. Colombo. All right, it's 11:30. We're going to take a 5-minute recess. And what we used to, as I said, I was a privilege of serving as a judge on the Navy and Marine Corps trial judiciary. We had a thing called a health and comfort break. You can, I think, probably figure out what we need. So the court's going to be in recess for 5 minutes, and I'll look forward to seeing everyone in a few minutes. Thank you. short recess. We're back on the record. It's 11:45. I'm sorry, gosh, it's 11:35. The date is Thursday, November 9th, 2023. We're on the record in the matter of LeBrant et al. Versus Secretary of State of et al. Court's case number 23-000137. Mr. Colombo, I believe it is your opportunity to present comments.
Thank you, Your Honor. May it please the court. Michael Colombo on behalf of Donald Trump. As discussed before, I'm just going to run through a couple of essentially rebuttal points. Incorporate by reference earlier comments. The plaintiff's position is that any voter in Michigan has the right to seek the declaration that a presidential candidate is ineligible and should be stricken from the ballot. A case that the plaintiff mentioned was Malinga. I don't have that case in front of me right now, but it is my understanding that that case involved the statute that does not apply to federal candidates. In any event, it was
Judge Malinga had been a longtime serving county prosecutor. Then he was, I think, appointed to the bench and then subsequently elected several times in Macomb County in the 16th Circuit. He was a probate judge, not a circuit judge, but served cross-assigned to the circuit court. And he stepped down in order to seek a U.S. House of Representatives congressional seat. That was a federal election.
Yes, but the statute that was disqualifying him, it was based on a state law disqualification, right? That's my understanding.
Right.
Yeah. Right.
Yeah, there's a provision in the state constitution, I think,
So
that says if you're a sitting judge, you may not run for any other elective office for a certain period of time until after you've left office.
So, whether the state has, well, first of all, that was not a disqualification under Section 3. It was not a disqualification that applied to a presidential candidate. This case is about disqualification under Section 3 of a presidential candidate.
Why does that make a difference?
Because, as discussed in Anderson versus Calabrese, which you mentioned earlier, the answer that we land upon cannot be one that causes a crisis or wreaks havoc in a national federal election, and that's an important distinction when you're talking about a presidential candidate. We cannot have a patchwork of 50 states in the District of Columbia with different standards that apply. We can't have one state dictating who may or may not be president by virtue of their independent disqualification of that candidate. No case we're aware of involves a court striking a candidate from the ballot, much less a presidential candidate from the ballot, over a disputed disqualification under Section 3.
But assume for a moment that after a hearing, this court or some other jurisprudential body were satisfied by a preponderance, clear and convincing, beyond a reasonable doubt, whatever the standard might be, that the conditions precedent to Section 3 being effective had taken place. Made the factual findings, took evidence, made credibility determinations. Is it your position that that court would not be able to then say the proscriptive language of the first vast majority of Section 3 does not apply?
It is our position that a court cannot adjudicate Section 3 disqualification at this time. The standards.
When could they?
What, excuse me?
When, if ever, could they?
When Congress had an enforcement act, it did allow federal attorneys to go into court under quo warranto
Actions.
To enforce Section 3. Right now, that legislation does not exist. It is a political question for the reasons that we've discussed before that is committed exclusively to Congress to resolve those challenges of a candidate's eligibility to hold office.
But I mean, it's almost as old as the Constitution itself. Marbury v. Madison, the Chief Justice Marshall, the fourth Chief Justice of the Supreme Court, wrote, "It is the duty of the court to say what the law is."
Yes, but in this case, our constitutional framework is such that Section 3 does have a prohibition. It is not self-executing by its own terms, and the forum for adjudicating a Section 3 dispute is in Congress. As Your Honor was asking plaintiff's counsel, by allowing states individually to snipe presidential candidates off their ballots, you are nullifying Congress's ability to subsequently do its job under the Constitution to evaluate the qualifications, potentially remove the disqualification.
Is there any candidate that could be nominated? So let's say hypothetically, a state party in Michigan provides to the Secretary of State an individual who is 30 years old. So, and had just turned 30 when the name is submitted. The just turning important because at no point in time during the term of presidency that this individual would stand for election would they have reached the constitutional age of 35, which is required. So we have, they submit a name of a 30-year-old who is not a United States citizen and has not resided in the United States for the last 14 years. There's no remedy for the submission of that candidate who literally would have 3 disqualifying circumstances?
Your Honor, that obviously that's not the case we have here, but I would agree that there are a lot of cases that do indeed hold that where disqualification under Section 2 at least, such as age or national citizenship, that where that is undisputed, stipulated, conceded, what have you, and it can't be fixed or removed, that indeed courts are striking those candidates from the ballot. However, a lot of what we've just been talking about, especially with the Secretary of State, has to do with the adjudicatory process. And to be clear, our position is that when it comes to an adjudication of a disputed disqualification under Section 3, that is something that is committed to Congress. And that additionally, the disqualification.
Where does it say that? What statute, what amendment, or what article of the United States Constitution says that?
In our view, plaintiff's conception turns the Constitution on its head. Our federal Constitution does not start with the premise that the states have the right to control who becomes the president, at least not individually. There is a process through the elections and the electoral process, electoral college, what have you. But where you have a standard in the Constitution, we have the concept of self-execution, we have the concept of political question. The starting point is not the assumption that states have the power to enforce Section 3. The starting point is the assumption that Section 3 is not self-executing, that adjudication of these disputes are with Congress. Section 5 itself says Congress shall have the power to enforce through legislation. If everybody had the power to enforce Section 3, it would have said so. It said that Congress has that power. Congress has exercised that power. There were decisions such as the Griffin case at the time that the 14th Amendment was enacted that said it had to be enacted through congressional legislation. Congress exercised that power. Eventually it repealed that. As you mentioned before, it's reconsidered a couple of years ago, reinstituting some kind of legislation, but it has not done so. Also just want to emphasize an issue that the court asked about for briefing, and that's the difference between holding office and running for office. Earlier, we discussed the legislative history of the 14th Amendment. When we were talking about it verbally, I didn't quite catch what the court was asking about, but I believe the court was asking why, or if there's any significance to the fact that the 14th Amendment in one of its earlier drafts indicated that it would bar running for office as well as holding for office.
Say running, but you had different language.
Right. But that in the final draft, in what was enacted, that language isn't there. And I think the implication is that that was a conscious choice. In addition to the layer of Section 3 allowing Congress, if it chooses to remove a disqualification, in addition to the 20th Amendment, which allows Congress to not seat the winner of an election until a disqualification is removed. And in the case of a president, put the vice president in until the president does qualify. And I just want to mention the cases of term limits and Schaefer, which we discuss in our brief, which further emphasize that you can't take a qualification or disqualification and turn it into a ballot access requirement. One thing in terms of Baker versus Carr and political question, a key issue there that I think the Secretary of State also touched upon is that there is a lack of judicial standards. There is a lack of clarity here over what exactly is subject to what kind of conduct constitutes disqualifying conduct under Section 3. There's been extensive briefing about what exactly is an insurrection or rebellion and what it means to engage in insurrection. Under Michigan law right now, there's nothing to guide the Secretary. They don't even have procedures for even engaging in such an adjudication. And then looking at this issue on a national scope, we can't have Section 3 meaning different things in different states. This would just wreak havoc and chaos on our federal presidential elections. As the court knows, even in this case, even though it had a relatively early start, over a year before the election, we are already jammed up against deadlines to get this case through the courts. And as we speak, there are similar copycat cases, maybe several dozen of them throughout the country, all trying to get through the courts in just a small window of time. That can't be the system. And everything that we've talked about suggests that the Constitution has a different concept in mind, where disqualification is adjudicated in Congress after the election. This idea that every county in every state.
Part of the comments, no, never mind, go ahead.
I mean, and there is a human disincentive, built in. I mean, it is part of the election itself. It's part of the the rhetoric and the politics of the election. Everybody knows that the issue is out there, and voters get to make their choices. Parties get to make their choices. So there's both the political process in terms of the election, as well as the constitutional process in terms of what happens in Congress. The Constitution sets the qualifications for office. It cannot be different state to state. It is fundamentally and quintessentially a federal function. Secretary of State has admitted that they have no vehicle to do this analysis, but this brings us to another issue. The first claim for relief in the plaintiff's complaint, we've all been talking today. I think maybe it hasn't been clear as we've been talking. The first claim for relief in the complaint is asking this court to declare that my client is ineligible. Mm-hmm. That's problematic because we're sitting in the court of claims. That doesn't appear to be something that is suitable.
Why not?
This is.
I'm pretty sure I know how to do hearings. I've admittedly probably only had 10,000 matters as a circuit judge, but I think I have some muscle memory on that.
It's our understanding that this is a court for claims against the agencies of the government, the state government. So mm-hmm. It's different if the plaintiff was asking, as it does in other claims for relief, that the court order the secretary to do something. But here it appears that claim at least number one for declaratory relief for this court to presumably hold a trial of some kind or discovery process, etc., would not be a claim against the secretary. And it's for that reason that we're only amici in this case.
Right.
So if you have any questions, I'd be happy to answer them. But
let me just review my notes if I could for a moment, Mr. Colombo.
Yes, sir.
Thank you.
May I add one more point?
the risk that every judge takes when you look down at your notes.
The silence.
These darn lawyers, they'll figure something else out to say.
Can't handle the
Mr.
silence.
Colombo, I'd be happy to hear whatever it was you were thinking.
Very small point. In terms of looking at the 14th Amendment and the landscape, the historical and legal landscape upon which it was written, the proposition that the 14th Amendment enacted in the wake of the Civil War was actually a vehicle to pass power to the states in order for the states to be able to dictate who gets to be the federal president is highly unlikely.
Thank you. All right. Now, if you think of something else, I may let you address it, but let me just take a look at my notes real quick. Thank you, Mr. Colombo.
Thank you, Your Honor.
Mr. Brewer, before you
Honor.
go, thank you. Before you go into your comments, I just wanted to memorialize at 11:37 during opposing counsel's beginning remarks, he indicated he was going to sort of adopt by reference what he had spoken of in case 230128. I looked over to you at that time and you nodded. I took that to mean that you had no objection and you were fine with that request for incorporation. Did I understand it correctly, or do you want to be heard on that?
Yes, Your Honor, you understood me correctly.
All right,
You can
so,
incorporate those arguments and proceedings by reference here.
great.
And I've
And
been responding to them all morning anyway.
yes, I understand, but I just wanted the record to be clear on that. And let me just inquire of Sister Counsel if she has any objections to that. And so Sister Counsel indicates that she does not have any objections to the incorporation or to Mr. Brewer's comments. Is that correct? Thank you. Mr. Brewer.
Thank you, Your Honor.
You're welcome. Oh, the pocket constitution. Excellent. I've been carrying mine around in my briefcase essentially nonstop since
Very handy.
about certainly September 25th.
So Your Honor, you've had repeated questions about the text, and particularly in relation to the political question doctrine. There is no text in the Constitution that commits the question of the qualifications to the Congress. The only two relevant texts here when it comes to this question are in Article 2, Section 1, which says, each state shall appoint in such manner as the legislature thereof may direct a number of electors. So this presidential process is in the hands of the state, not in the hands of the
Article
Congress.
2, section, I'm sorry. Section-
Article 2, Section 1. That's where the Constitution says the states determine how they're going to run the presidential election process, up to and including the selection of electors. That's the process we are in. Not committed to Congress, committed to the state. The second textual text, which is very important here, is that last clause of Section 3 that we've been talking about. The only role for Congress in Section 3 is to provide amnesty. There's no other textual commitment in Section 3 to Congress to do anything. It has a very limited role, amnesty under the proper
Oh,
circumstances.
it doesn't say amnesty. It says, quote, but Congress may by a vote of 2/3 of each house remove such disability, period, close quote. And there's a comment in there too. So, and it's essentially amnesty. I get
That's
that.
right, commonly referred to as amnesty.
Right, right. But if your position is correct, how do both houses have an opportunity to exercise that removal authority? And I know you said you could do it prophylactically. You could, if I had been an officer in the Confederate States of America's armed forces and I wanted to run for Senate, and I was a graduate of West Point, so I'd taken an oath to uphold and defend the Constitution previously, I could have then, before the general amnesty statute was passed, I could go to Congress and seek a private bill.
That's exactly what happened for hundreds of Confederates.
Okay, did those private bills, was that after they had been elected or prior to? And that's the one thing I have not been able to sort out from the historical record.
I think, based on what I know of the historical record, it was a wide variety in people who wanted to run for office and wanted it lifted. There are people currently in office who said, I'm in jeopardy in office, I need it lifted.
I get that, and that's, I can understand those who are in office who, whether it's through the Quo Warranto cases or whatever, who are seeking to have the disability removed. But that's why the hold is a question for me. No person shall be, as opposed to shall run. It doesn't say shall stand for election, or it says no person shall be a senator or representative in Congress or elector for president or vice president.
Your Honor, I think here, if I may, I think Justice Scalia's observation in Heller, in the Second Amendment case of Heller, is worth, if I recall the case and his quote directly, that look, the constitutional text should not be read in a technical sense. It should be read in a common sense sense in terms of office and officer, which we heard argument about this morning. Clearly those apply to the president. I think here as well. But again, I understand your reading of the language there, but there's also Article 2, which commits to the states the ability, the power, the authority to determine who will be candidates for president on their ballots. So it's not just Section 3, Your Honor, and its wording. It is the power, the coextensive power under the Constitution of the states to determine the eligibility of people on the ballot. Fleshed out here by the Barrow case in Michigan, which gives every voter the right to question the eligibility of any candidate on the Michigan ballot. If I may, Your Honor, whatever limited time I have left, we've heard this morning about chaos. If various courts around the state at this point were to rule Trump ineligible. Two answers to that. First of all, the judicial process will play out here very quickly. As you know, courts in this state are very good about promptly deciding election matters. I expect within a day or two of whenever you issue a decision, we will be in the Michigan Supreme Court and thereafter in the United States Supreme Court. We will be there very quickly. It'll be resolved. But the important fact is that ultimately your case or one of these other cases is going to be resolved by the United States Supreme Court, and we will have a uniform rule. So this talk of chaos in this period, I think is just that talk. The United States Supreme Court is going to resolve this. Now, but the alternative, Your Honor, is worse, because what we hear from Mr. Trump is, well, let's wait to decide whether I'm eligible till January 6th, after I've been elected, in his view. Or let's wait till January 20th, when I'm going to be inaugurated, in his view. Talk about chaos, Your Honor. That would require the country then to what? Rerun an entire presidential election? It's in this country's interest to resolve these important constitutional issues now. There will not be any chaos because the Supreme Court will ultimately rule on this question.
And we're into more time, but I have a couple of questions I'd like to ask you.
Yes, sir.
If you don't mind. What do you make of the 25th Amendment and that portion of it? I'm sorry. Sorry, not the 25th, the 20th Amendment. And this was adopted and made part of the Constitution, January 23rd, 1933. In Section 3, it talks about, and I asked you questions about this in this case and in 128 as well, declaring who should act for president and the failure of the president to qualify. But there's also language about how the vice president shall have qualified, declaring who shall then act as president, or the manner in which one who is to act shall be selected, and such person shall act accordingly until a president or vice president shall have qualified. So how does that happen? How do we get, if we've already figured out that the president-elect and the vice president-elect aren't qualified under the 20th Amendment, Section 3, are we talking, is that suggesting there's a whole nother general election, a whole nother presidential election? Do you have a position?
Your Honor, that may be one possibility. Obviously, we have the Succession Act.
Right,
Beyond
right. That gives the openings, but even the Succession Act talks about until a president is selected. And I haven't found anything in my reading that says, okay, and here's the playbook. Here's what you do.
As far as I know, Your Honor, there is no statutory playbook at that point. I think our point was none of this language gives Congress the right to decide who is qualified. That's the issue before the court. There's no textual commitment here to Congress to determine who is qualified to be president in the first instance.
And you don't think the McCain and President Obama cases hold differently?
In what way, Your Honor, if I may ask?
Yeah, that when the discussions and the cases about Senator McCain's qualifications, and my memory tells me it was whether having been born in the Panama Canal Zone as a dependent of an active duty service member, is he a U.S. citizen by birth? I think that was the question. And for President Obama, there were individuals who believed that he was not a citizen of the United States. And it seems like a lot of those cases address the justicability issue, and they say this is not an issue for the courts, this is an issue for Congress. Do you agree with that as a general proposition, that that's what they said, or?
Your Honor, because frankly, I think that's a misreading of the political question.
Okay, but do you agree that the cases said that?
But I think they're wrongly decided. And there
Okay.
are many cases, as we cite in our brief, and in the amicus curiae submissions, which will otherwise, including recent cases. You know, the case in Colorado that's been litigating as we speak, the court rejected the application.
Well, there's no final order in that.
No
but
final order,
No,
but
that judge
They
did.
did not dismiss.
That was I read the entire opinion, very commendable. I wish that, my writing was as precise and as thoughtful as that judge's. So,
You know, that's just one of many that we cite. I'll just leave this with Your Honor, pages 17 and 18 of our brief, many cases which reject the application of that doctrine here.
okay,
I believe my time is up.
it is.
Thank you, Your Honor.
Ms. Brewer, thank you so much. Ms. Coneybear, thank you so much. On behalf of the people, any final comments before I submit the matter? Let me just turn this timer off. If I can figure out how. I need my 30-year-old children to help me with my iPhone. Counsel? All right, from people, nothing. Mr. Colombo, anything else? All right, thank you. The court thanks the attorneys, the amicus filers, those who appeared here in court, and those who were not given the opportunity to present oral argument. The positions are all well and capably stated. This matter 23137 will be submitted for the court's consideration. All right, we're now at 8 minutes after noon. The next case was set to start at 2. My preference would not be to start it at 2, but rather started earlier than that as opposed to later, unless somebody has something really important they need to get done. But I first want to ask Ms. Roberts what her preferences are. Excuse me. All right. Oh, gosh. Oh. Can I have a transcript of that? So I'd like to provide that to my family, and maybe someone else. All right, so Mr. Brewer and Ms. Coneybear, you will not be presenting oral argument in the next case. The two counsel that will, or two tables of counsel, are here. What's your preference, counsel?
I have no objection.
All right, say, all right, it's 10 after, let me just, Mike, you over there? All right. Let's do a 30-minute recess, and we'll reconvene at 20 minutes before the hour 1. And then we'll proceed into the final matter that's on the court schedule for today. Any objections from the state? All right, from plaintiff Trump?
No, Your Honor.
All right, court is in recess. Thank you. Everyone can go about their business. We'll see you in 30 minutes. I'm going to stay here for a minute. You don't need to stay.
Thank you. Please be seated. Ready?
All right, good afternoon. Court calls the case of Donald J. Trump versus Jocelyn Benison in her official capacity as Secretary of State. This is case 23-00151MZ. My name is James Robert Redford. I'm the Court of Claims Judge for the state of Michigan who has been assigned the responsibility to preside over this matter as well as over matter 23-00128 and which is Robert Davis versus Jocelyn Benson in her capacity as Secretary of State, as well as 23-00137. If counsel could, as I said at the start of our second hearing, the folks who are watching had asked, can the lawyers please go to the podium? So if I could have both counsel from plaintiff side and counsel for the defendant just approach. If counsel for the plaintiff, Mr. Trump, if you could indicate who you are and who co-counsel are with you and anyone else.
Your Honor, Mark Moisier on behalf of President Donald Trump. With us today are Dave and Steve Kelman. And before you is still pending is Mike Colombo's pro hoc vici motion, which you have all the paperwork, but I have not.
Well, since he's argued twice already, I suppose I probably should grant that motion.
You've already granted it in the other two cases. You just haven't done in this
All
case.
right. I grant the motion, or is there any objection by the people? I grant the motion. I'll sign the order. I may have already signed it, but I don't know. I've signed a lot of orders in these three cases in the last several days. So that's fine. Thank you. And then Ms. Mindguest.
Yes, Your Honor, Assistant Attorney General on behalf of Secretary of State Jocelyn Benson.
All right. Thank you. In the second proceeding today, 23-00137, everyone who had discussed previously asked for the court to sort of consider, not sort of, but to consider and adopt by reference the council's prior statements in case 00128. Before we got started this morning, or I'm sorry, this afternoon, in this matter, I wondered if we wanted to engage in that process as well on behalf of the plaintiff, Mr. Musser.
We have no objections to all arguments in 128 and 137 being applied to this matter.
All right, thank you. And on behalf of the secretary?
Objection, Your Honor, we support that.
All right, before we get started, is there anything that we should address in addition to what we've already talked about? And let me just hold on just a moment. There's Mr. Musser. Yeah, Mr. Musser, I've got your pro hoc vice order signed, but Mr. Colombo, how on earth did I let you argue already? You know, I think we should strike all, let's start over again and let's have Mr. Musser argue.
No, Your Honor, you had signed it in the, as the amici counsel. It's
Oh, I see.
just not in this third case.
Okay, well, I guess we'll not hear all the arguments again then. Anything on behalf of the plaintiff before we get started?
The pro hoc vici was the only issue we had.
Okay, thank you. And anything on behalf of the Secretary of State? All right. One of you can stay at the table. One of you gets to go back. Oh, it's Mr. Colombo again. The one who wasn't authorized to present is going to
Exercise my new authority.
right.
I'll keep this brief, Your Honor.
Yeah. Thank you.
Good afternoon, Your Honor. Michael Colombo on behalf of plaintiff Donald Trump. Our complaint asks the court to enter a declaratory judgment confirming that the Secretary of State has no authority to refuse to place President Trump's name on the ballot and enter an injunction stopping her from not placing him on the ballot. The court asked the Secretary of State some questions. One of those questions is in your order. You asked for a written briefing. And one of those questions was whether the Secretary of State has an affirmative duty and the authority to decide whether a candidate may be placed on a ballot prior to a court's review of the issue. Secretary of State's answers on file with the court and also consistent with what has been represented in court today are dispositive of this case, as they concede that she has no duty or authority under Michigan law, Michigan Constitution, or the U.S. Constitution to keep my client's name off the ballot. For determining the names.
But you agree that, well, any court will always give respectful consideration to the position of counsel and to the position of parties. A determination of what the law is, the court is not, no court that I'm aware of in the United States is bound by that either agreement or stipulation. Do you agree with that?
Absolutely, Your Honor.
Okay.
Just to say that the parties.
No, yep.
To determine the names that go on a primary election ballot, the Secretary of State's answer states that pursuant to 614A, the Secretary of State must identify the names of potential candidates mentioned in the media and obtain a list of candidates from the state party. Secretary of State acknowledges that Michigan law at section 168.615 states that she shall put those candidates' names on the primary election ballot. For the November election ballot, the Secretary acknowledges that the names on the ballot are determined by the major political parties through their respective conventions. The Secretary acknowledges that no language in sections 614A or 615A or any other section of Michigan election law requires or authorizes the Secretary to determine whether a candidate for president meets the qualifications for office or is otherwise eligible to run or hold that office if elected. Secretary notes that unique among state and federal candidates, presidential candidates are not required to affirm their qualification in order to be on the ballot. Secretary therefore concludes that, quote, there simply is no statute in Michigan election law that imposes upon the Secretary a duty to determine whether a candidate for president meets the qualifications for office or is otherwise eligible to run for or hold that office if elected, nor can such a duty be implied from any statute, particularly where the legislature expressly relieved presidential candidates from making any affirmation that they meet the qualifications for that office. The legislature's drafting choice strongly suggests that the Secretary has neither the duty nor the authority to prohibit a presidential candidate who lacks the constitutional qualifications from appearing on a primary or general election ballot. As to the 14th Amendment, the Secretary concludes that whether the 14th Amendment bars Mr. Trump from appearing as a presidential candidate on Michigan's ballots is a federal constitutional question of enormous consequence. Michigan courts have held that administrative agencies generally do not have the power to determine constitutional questions. And here, where the legislature has not authorized or required the Secretary to determine or confirm whether candidates for president are qualified and eligible to serve, she has no authority to determine this constitutional question. Our complaint asks for a judgment confirming that the Secretary has no authority to refuse to place President Trump's name on the ballot, and for the court to enter an injunction stopping her from doing that. The Secretary has conceded that the law requires her to put my client's name on the ballot in the normal course, and she has no authority to determine.
She does as to the primary ballot.
She does.
As to the primary election, not the general election.
Well, one of the Secretary's statements is that the legislator's drafting choice strongly suggests the Secretary has neither the duty nor the authority to prohibit a presidential candidate who lacks constitutional qualifications from appearing on a primary or general election ballot. At least that's the position that they've stated. Our additional constitutional arguments only serve to corroborate that the Secretary has no such power. We agree with her statements of the law. And just a couple of other points. Miki LeBrandt's brief, he claims that a case we rely on, Robinson versus Bowen, was reversed by a case called Lindsay versus Bowen. We direct Your Honor to that opinion to see the language for yourself. In Lindsay, the court said the following, which supports our position, that it is constitutional to list a candidate who disputes their qualification. This is a quote from Lindsay.
What's the site?
This is 750 F3rd 1061 at page 1065. Decision was issued in 2014. It says the quote, "But at worst, McCain's eligibility was disputed. He never conceded that he was ineligible to serve, and it was generally assumed that he could. The Secretary does not violate the Equal Protection Clause by excluding from the ballot candidates who are indisputably ineligible to serve, while listing those with a colorable claim of eligibility." I'd like to note for the court that this week the court received an amicus brief from the Republican National Committee and an amicus brief from the Michigan Republican Party and 6 other state parties. These organizations have unique positions, interests, and arguments.
I've read them in their entirety.
Thank you. Your Honor, with that, we respectfully request that the court grant the relief we requested.
Okay, hold on just a minute, please. Your complaint's not verified.
Your Honor, Mr. Moiser can address that issue.
Your Honor, neither is LeBron's case.
Pardon me?
LeBron's 137, their complaint is not verified either.
Right, well, nobody interposed that objection until just now.
Okay.
Yours is not verified. How does this court have jurisdiction?
I could file a verified complaint today. We were
It
under
was
a very,
pled. Just a second. The deficiency was brought to the court's attention in a previous filing, but I had the chance to read. I'm assuming counsel did as well. Fair?
fair.
Court issued an order on, I think, October 16th, indicating that the plaintiffs in this case motion to intervene was denied
Yes.
and was given leave to file another amicus or another proposed parallel proceeding in accordance with the rules of the court and the laws of the state of Michigan. Fair? Okay. How have you complied with that?
Your Honor, I do have a verified complaint that I could, because subsequent to the court's 4 o'clock deadline that we had, we were able to get our clients verified. I could get that on file for you. But when we filed it identical to how complaint 137 was filed, and that complaint was also not verified. So we kind of followed the example of the.
Sit down, Mr. Brewer.
In our complaint, it was verified by local counsel, Dave Kellerman.
Pardon me?
It was verified by Dave Kellerman. Local
No,
counsel.
it's not. The verification, there is a specific provision of how a verified complaint is to be filed. And there's in the language, it says, verified complaint for declaratory judgment. Okay, that's how it's captioned. However, that which the laws of Michigan require to have it be a verified complaint are not contained within 12 pages unless I'm missing it. And if I am missing it, please point it out to me.
Obviously, I wasn't pro hoc vici at when the complaint was filed, so my understanding was that it was verified by Dave Kellerman, and that I have subsequently received a verified document by Donald J. Trump that I could get on file.
If you want to check with your co-counsel briefly, I'm happy to give you a minute to discuss this.
Your Honor, as I said, if the court so desires, we can file an amended pleading with the verification by Donald Trump, the plaintiff. I'm
not telling any party how to file a specific pleading. I'm just trying to find out whether or not the pleadings are in conformance with the core rules.
understand. And I would just ask leave of the court. We have it available that we can get that on file by the end of the afternoon.
Any objection by the secretary?
Certainly, I'm sorry. You can't fix the verification issue through filing an amended complaint.
I don't know.
I apologize that I didn't catch this earlier myself. I would state for the record that if Mr. Trump was to file a new complaint with all the proper verification on it pursuant to the statute, electronic service of that in order to get this long. I recognize that everybody acted quickly in this, and that this is a mistake that happens frequently.
All right. Anything else, Mr. Minister?
No, Your Honor.
Thank you. Counsel.
Thank you, Your Honor. Heather Mingus on behalf of the Secretary of State. This will likely be my shortest presentation as the court has kindly incorporated all of the arguments that we've previously made. Counsel for Mr. Trump have sort of accurately portrayed our position, reading from our memorandum of law. So all of that was correct. It is the Secretary's position, of course, that she does not have the authority to disqualify Mr. Trump from the ballot. But we also recognize that is a legal question that is in front of the court in the other cases as well. So while it's our position, I don't know that we've conceded, so it's, I think, an open question, so it's our position. But recognizing that the court might rule differently, so. And just, again, clarifying that, we're not arguing one way or the other on his eligibility. It's simply not our call, so.
All right. Thank you. What's your position on an amended verified? You're saying you don't think that can be done?
I should know this, Your Honor. We have several recent cases. I don't know if it's the Christie case from the Supreme Court, but they're recent ones. Like, confirm with Mr. Brewer or not, but I don't believe you can fix the verification through an amended complaint. I believe that I moved on this in an election case a while ago, and they fixed it through the filing of.
Pardon me?
I just don't think I don't believe the case law holds currently that you can fix the verification through filing of amended complaint. If you want a supplemental filing or want to take a break and we can look at that case law and just double check, I'm happy to do whatever. I'm sure Mr. Trump's counsel are happy to explore that as well.
All right, take a 15-minute recess. We'll reconvene at 1:15 and we'll address this specific issue. Thank you.
Thank you.
And if the parties, everybody wants this case to move forward and the other two cases, and so does the court. So if everybody wants that so that we can get a decision from higher courts than this one, I'm willing to hear what the parties suggest if there's some stipulation to proceed, or, I'm willing to listen when we come back on the record. And I note for the record that Mr. Davis, the plaintiff pro se in the case 00127 23-00128, and Mr. Brewer, counsel for the plaintiffs in 23-00137 are both present in the courtroom. And when we come back, I'll look forward to hearing from the counsel of record in 151 and open up the possibility that I would listen to counsel in 137 and pro se in 128. I'm not saying I'm going to, but I'm saying I'm putting it out there. Everybody understand? Any questions, Mr. Brewer? You looked like you had a question.
Yes, Your Honor. Thank you very much. We filed a verified complaint. I have a copy of it with me. I'd be glad to share it with the court. And frankly, the fact that the argument of Mr. Trump's counsel that we didn't does not excuse his failure to file a verified complaint. So I have no idea why that issue is even being raised here, and it's really not appropriate. We filed a verified complaint.
All right.
But I'll be prepared to address the court if you need me to, Your Honor.
All right.
Thank you.
And I get, right. All right, we'll reconvene at 1:15. Court's in recess. All right. The time is 19 minutes after the hour of 1. It continues to be November 9th, 2023 in Grand Rapids, and we're back on the record, and we have a new face at the podium, and you, sir, are?
Good afternoon, Your Honor. May it please the court, David Coleman, Michigan Counsel for Mr. Trump.
Mr. Coleman, please.
Thank you. Thank you, Your Honor.
Thank you.
We've had an opportunity to review the Christie decision versus Wayne State seems to be the case here. It's 511 Michigan 39. It's just a few months ago. It's a 2020.
If I remember it well, there was I had a Court of Claims case that had an identical issue that Wayne State was the defendant on, filed within 3 days maybe of that decision. So there are 3 cases: Progress Michigan, Christie, and Elia.
Right. So essentially under Christie, and I think the Attorney General's in agreement that this is a curable defect within 1 year. This jurisdictional issue would only arise after 1 year from the accrual of the claim.
Do you
I believe
agree?
we have,
Do you agree, Mr. Kelman, that it's not verified at this juncture?
that's correct.
Okay.
Yes.
All right.
And the AG has stipulated that we can cure the defect by filing an amended verified complaint, and we will do so promptly because we have it already. It's
When,
to that.
all right, will there be any difference? And
No.
I mean, an additional sentence, an additional comma, an additional anything
No, absolutely.
other than the verification required by 600 MCL .6431.
That's exactly correct, Your Honor. I should have said that.
No,
We will
I
make
just-
absolutely no changes.
Okay. And, but you'll attach the verification.
Right.
As required by the statute,
Yes.
right? And when do you expect to be able to do that by?
I would say no later than tomorrow. We'll try to do it this afternoon, but I guess, we have to get back
All right.
to our office.
Tomorrow, as the attorney for the secretary indicated, is a state holiday, but being the lifelong member of the Scouts, to try to be prepared, I asked my staff to contact our clerk's office, and I will be able to get a filing tomorrow because even though it'll be a holiday, I'll have someone from the clerk's office. So can you get it filed by noon if the court gives leave to do that?
Absolutely, Your Honor. No problem.
All right. I don't have it. Mr. Kelman, do you have a business card for the most important person in the courtroom, our court reporter? Thank you, Mr. Kelman. All right. On behalf of the secretary, what's your position? Yes, the verified complaint.
Yes, Your Honor. Thank you. Heather Mangus on behalf of the Secretary.
And I would like to note also, I have spoken with staff and I am advised that Mr. LeBrant's pleading through Mr. Brewer and his co-counsel has been verified, is a verified complaint. And so that, Mr. Brewer, I agree with you with your statement according to, and it was my recollection that it was, but there've been enough pleadings. I confess I may have missed stuff. So do you agree with that, Mr. Kelman?
Your Honor, I'd just like to get on the record. We got a copy of the complaint that was filed with the court. The copy we got apparently did not include the verification page. And so we saw from the AG that was there, but the copy I had
I
did not
understand.
have it. So that was
All
a
right.
misunderstanding, Judge.
All right. I just wanted to, I'm trying to, and I apologize if I'm disjointed in the manner in which I've been conducting these hearings. I am just trying to make as complete a record as we can for the members of the Court of Appeals or the members of our state Supreme Court or any other tribunal that's going to have to review this. So I saw this. I want whatever decision is made ultimately to be one that will be able to move, anybody can move forward on. And that's why I brought it up. So, but what's your position on where we're at on this and on Mr. Kelman's statements?
Yes, thank you, Your Honor. Sorry to have caused some alarm with suggesting that might not be curable by an amendment, but
Since I gave no notice of this issue to anyone, including the law clerks who have been helping me so much, you have no reason to apologize. If anyone should apologize, it's me that I didn't bring this to the party's attention and to, more importantly, candidly, to the law clerks. Because when I went back in chambers, phone is exploding with another lawyer who helps the court try to get to the right place. Judge, no, you need to know this. So at any rate.
Nope, no problem, Your Honor. So yes, in my reading of the Christie and the Elia case together suggests that they can amend the complaint because we're within the 12 months. So, and I have indicated to counsel for Mr. Trump that I, am amenable to the amended complaint and that we'll agree to accept service electronically so that we can help. Just, I guess we don't need to accept service since it's an amended complaint anyways, but we agree to it and we'll
All right.
have no problem with that.
You have no objection to the
No, I
court
have no
allowing them
objection.
to do that by noon tomorrow.
Correct.
All right. Mr. Brewer, Mr. Davis, gentlemen, if you could both approach the podium, just so I know you're not of record in this case, you're amicus, but I'd like to offer you the opportunity to make a statement. Mr. Davis, you have the case number is 128, his is 137, so you get to go first. Mr. Davis.
Thank you, Your Honor. I'm very pleased that you read my amicus brief that highlighted the fact that their complaint was unverified. In addition, Your Honor, I'm glad you asked them the question whether or not they were going to change anything else in the complaint, because that doesn't cure another problem that I pointed out in the amicus brief filed with the court in this case. They seek relief under federal law.
Okay, nope, I understand that. I'm just, and I understand the position you took, and I thank you for it. Do you have, in the manner in which Mr. Kelman proposes he will proceed on behalf of plaintiff Donald J. Trump, do you have, and that it's going to be the exact same complaint? Do you have any objections?
If this is the exact same complaint, they're seeking relief under the Federal Declaratory Judgment Act, which this court lacks jurisdiction to.
Right, I understand that's your position on that.
So then,
But as far as the verification
that
aspect.
is, I would agree that the case law addresses that.
Okay. All right. Thank you, Mr. Davis. Mr. Brewer, and thank you for pointing out to the court that your complaint was in fact verified. I agree with you. But as far as that which Mr. Kelman has indicated he would interpose to do, the state does not object. Mr. Davis, it sounds like does not object. Do you have any objections?
No, Your Honor.
All right. Is there anything else you'd like to say? This might be the last lawyer for the day speaking at the vote.
No, Your Honor. Thank you for checking the court records and confirming that we did file a verified complaint
Indeed.
and we have no objection to how they're going to proceed.
Thank you, sir. All right. The court, as relates to the issue of whether or not the plaintiff's complaint in case 23-000151MZ was a verified complaint, or whether, if it was not, whether that defect can be cured. The court finds that it was not a verified complaint in accordance with MCL 600.6431, but the court additionally finds that the amendment and verification can be undertaken to allow the court to exercise jurisdiction pursuant to Progress Michigan versus Attorney General 506 Michigan 74, a 2020 decision of the Michigan Supreme Court, and two decisions from 2023 of the Michigan Supreme Court, Elia Company LLC versus the University of Michigan, 511 Michigan 66, 2023 decision, and Christie versus Wayne State University, 511 Michigan 39, 2023. insofar as the time period within which this court would have jurisdiction to adjudicate claims against the state of Michigan or a state officer have not expired, nor will they expire in the next 24 hours. The plaintiff does seek to file the necessary verification, whatever that might be, with the court by 12 o'clock noon tomorrow, November 10th, 2023. And the Secretary of State's attorney has indicated on the record she interposes no objections. Mr. Davis, in his own capacity, pro se, without waiving the deficiencies that he identified in his amicus curiae filing in this case, Mr. Davis, who's the pro per representative of himself and his claims in case 23-00128, as indicated on the record in this case 151, he has no objections, as has Mr. Brewer, counsel of record in case 23-00137. For those reasons, the court rules that plaintiff may file the amended complaint by noon tomorrow, November 10th, 2023, 12 o'clock p.m. Eastern Standard Time, in case there's any disagreement of what noon is. So I am, so that's court's ruling on the verified complaint issue. The verified complaint issue was brought up by the court because jurisdiction can be challenged at any time. And the court hopes to provide, well, the court felt I felt it was my duty to bring it up. So I did, and I'm sorry I didn't give the parties notice of it. I should, in hindsight, I should have. And sorry about that. And I'm sorry, I apologize to the outstanding legal research team of our court who they were almost, if not more surprised than the lawyers of record. So, so sorry about that. Anyway, that's on the verification and the complaint. Is there anything else from plaintiff in closing the proceedings in 157 in response to anything else? I guess sort of threw everybody for a loop there, including maybe myself, but
Nothing further, Your Honor.
all right. For the secretary, anything further?
For all your time today.
Thank you. And I'm going to ask just for acknowledgements. Mr. Davis, thank you for being here all day today. Is there anything else? I know you wanted to argue amicus, and I said you can't. And I know Mr. Brewer wanted to argue amicus, and I said that he couldn't under the court rules. And I know you wished or disagreed, and maybe you're going to appeal me on that. I don't know. That's okay. And we'll get good instruction from the outstanding judges of the Court of Appeals. But is there anything else, Mr. Davis, you would like to bring the attention of the court?
Just very briefly, and thank you, Your Honor, for your patience. And now that, for the reasons stated in the amicus brief that I filed in this case, filed by Mr. Trump, if nothing else changes in his amended complaint and he seeks the same relief that he cites under the Federal Declaratory Judgment Act, which was section, I believe, I don't know right offhand.
I remember you're writing about it.
It's his complaint.
Right. I'm kind of not looking for oral
Oh,
argument.
no. I just wanted to preserve.
Okay,
that
no,
particular- that
that
particular
is
issue.
preserve.
And thank you again.
All
for the
right,
signed
thank you.
report.
And thank you. And I appreciate the courtesies you've extended to the court today. Mr. Brewer, anything you'd like to add?
Mindful of the court's admonition that oral argument is over and that I'm not permitted to argue in this matter. We have nothing further, Your Honor.
All right, thank you, Mr. Brewer. All right. Thank you. The matter of Donald J. Trump versus Jocelyn Benson in her official capacity. The court's case number 23-000151MZ, conditioned upon the verified complaint being, or verifications necessary to comply with the requirements of the court rules, will be submitted for the court's consideration. And this matter is submitted with that proviso, obviously. The court wishes to thank Ms. Teresa Roberts, ma'am, for your being here today. It is always a privilege to have one of our outstanding professional court reporters here in court helping us. And I appreciate very much your being here. So thank you to all counsel and to Mr. Davis, our pro se party. Thank you for all the submissions. Thank you for your patience. And these three matters are submitted. The court will act with all possible deliberate speed to figure out what should happen next. And then that will be taken and it will be manifested in a written opinion. There will be, I would expect, three separate opinions and orders, since I have not consolidated the cases, nor I don't think anybody has moved for consolidation. But I think that's it. Let me just check quickly. Yes, counsel.
I'm just bringing to the court's attention that there is actually a fourth Section 3 lawsuit. We did bring it to the court's attention through a notice early on in the case.
The Castro case?
The Castro case.
My understanding is the Castro case that the complaint was never served.
That is our understanding, but I just, since we were doing house cleaning, I just wanted to make sure that that
And I
was
don't know the number, although I do know that the case number for that was assigned to a different court, and we usually assign the companion cases to the first assigned judge. So
I believe it's 122
I
or
don't know.
125.
It's not 128. It's
Yes.
a lower number. And at any rate, but that was not served. So that other judicial officer didn't have the privileges that I've had today to be with each of you and to enjoy very much the discussions that we have had. Let me ask our security director, anything further from you, Dan? Michael, anything? All right. You have the thanks to the court and the court staff. Appreciate very much everyone's professionalism and being here today. Ms. Roberts, again, thank you. Court is in recess. Time is 1:35. Thank you.